Yeah.
Taking the console.
Yeah, that's why I'm saying.
I can't. I'm sure we don't know who I can't know. Waking up early. I can stay late after that. What did you guys do?
All right. All right.
All right. Thank you. You may be seated. All right. Good evening or good morning. My name is Commissioner Elizabeth Campbell, and this is the 2 a.m. initial appearance calendar for April 24th, 2026. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. Persons appearing before this court are reminded that they have the right to remain silent and that anything they say could be used against them. Most of you have qualified for a court-appointed attorney. If you have not qualified for a court-appointed attorney, or even if you have, you may retain an attorney at your own expense to represent you. I will be calling you up individually. When your name is called, please proceed to the podium. At the conclusion of your matter, officers will have paperwork for you. That paperwork will contain my complete orders in your case. It will also contain the dates, times, and locations of your future hearings. I now need to read a victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, we are going to go ahead and start with Charles Armstrong, please, and then Michael Milaro, please. All right, sir, go ahead, state your name.
Charles Armstrong.
And Mr. Armstrong, what is your date of birth?
March 10, 2001.
I'm sorry, March what?
March 10, 2001.
Thank you. All right, sir. You are here because you were arrested on charges of armed robbery with a deadly weapon, a Class 2 felony, and kidnapping, a Class 2 felony. I did find probable cause for both of those. Based upon the information that you provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney. So I'm not appointing you an attorney this evening. This morning. You may, of course, retain an attorney at your own expense to represent you. I am setting hearings on April 30th at 8:30, May 1st at 1:30 p.m., and May 4th at 8:30. All of those will be in the downtown Maricopa County Superior Court. Because you were on release in your case CR 2026-103040 on the date of offense for your new felony charges, I am holding you non-bondable this morning. All right, go ahead, step to left, officer has your paperwork. Michael Malaro, please, and then Ramon Parra. All right, sir, go ahead, state your name.
Michael Joseph Malaro,
And Mr. Malaro, what is your date of birth?
July 10th, 1955.
Thank you. All right, sir, you are here because the Maricopa County Superior Court issued a warrant for your arrest based upon your failure to appear in your matter CR 2021-140816. In that matter, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you, so I'm not making that decision again this morning. I am setting a hearing on April 30th at 8:30 in the downtown Maricopa County Superior Court. Because this warrant is based upon your failure to appear for sentencing, I am holding you non-bondable pursuant to that warrant. All right, go ahead, step left, officer.
Excuse me, Your Honor?
Yes, sir.
I'm already in custody in Texas. I'm here.
Oh, I do see that.
Yeah,
I see that you were extradited from...
yeah, I signed extradition papers.
Okay.
So, I have no way of hiring an attorney.
Okay. And I do hear what you are telling me. That doesn't really change what I am obligated to do this morning. The warrant does say that you are to be held without bond. I did confirm it with the case history, and it does look like you failed to appear for sentencing. And I also see that you were in fact extradited from Texas. So that's another weight in my decision to hold you non-bondable.
Oh, yeah, I'm not.
Okay.
It's just the manner of the attorney.
Okay. So because this is a failure to appear warrant, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you. And one should already have been appointed for you if you were entitled. So let me look. It looks like you did have an attorney that was representing you in this matter. So I'm not doing anything this morning that's going to change that. So when you see a judge next on April 30th at 8:30, my assumption is that there should be counsel available to you at that point. Okay.
All right.
All right.
Okay,
if there's
thank
not, you can follow up with the judge then. All right. Ramon Parra, please, and then Jacob Begay. All right, sir. Go ahead and state your name.
Ramon Parra,
And Mr. Parra, what is your date of birth?
12/26/71.
Thank you. All right, sir. You are here because the Maricopa County Superior Court issued a warrant for your arrest based upon your failure to appear in your matter CR 2023-107247. In that matter, because it is a failure to appear matter, the court should already have made a determination about whether or not you are entitled to have an attorney appointed, so I'm not making that decision again this morning. I am setting a hearing on April 30th at 8:30 in the downtown Maricopa County Superior Court. Because your appearance here this morning was secured through a writ of habeas corpus, I am holding you non-bondable at this time. Okay?
I have similar questions to the gentleman just left. We both came from Houston.
Okay.
I'm in federal custody since 2023, so that's why they make my court date here at Maricopa.
Okay.
So, and I believe they told me I had a lawyer already. His name's Mark.
Okay. That would make sense. Again, your next hearing is on April 30th at 8:30. I'm just seeing you on the warrant, but that April 30th hearing, I would anticipate that your attorney or an attorney should be there on your behalf, and if an attorney is not there on your behalf at that point, you can follow up with the judge. Okay.
Okay.
All right. Go ahead. Step left. Jacob Begay, please, and then Anthony Hendricks. All right, Mr. Begay, go ahead, state your name.
Jacob Daniel Begay,
And Mr. Begay, what is your date of birth?
11/22/2000.
Thank you. All right, sir, you are here because you were arrested yesterday on 3 counts of aggravated assault, class 4 felonies, 1 count of resisting arrest, a class 6 felony, and 1 count of assault, a class 1 misdemeanor. I did find probable cause for all of those. I am appointing you an attorney. I am setting hearings on April 30th at 8:30 and May 4th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $25,000. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. You're not to reside at the same location as any alleged victim or go to the alleged victim's residence, even if you are an owner or renter of the residence. If you currently reside with any alleged victim, you must find an alternative residence. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're also going to need to obey the terms of any order of protection or injunction against harassment that has been issued or may be issued. All right, go ahead, step to the left. Officer has your paperwork.
Thanks.
Anthony Hendricks, please, and then Jenny Villarreal. All right, Mr. Hendricks, go ahead, state your name.
Anthony Joe Hendricks Jr.,
And Mr. Hendricks, what is your date of birth?
12/25/1973.
Thank you. All right, sir, you are here because the grand jury in Maricopa County issued a warrant for your arrest based on allegations that on or about October 26th, you committed the offenses of misconduct involving weapons, a class 4 felony, and tampering with physical evidence, a class 6 felony. In that matter, I am appointing you an attorney, and I am setting hearings on a hearing on May 1st at 8:30 in the downtown Maricopa County Superior Court. Pursuant to that grand jury arrest warrant, I am setting a secured appearance bond in the amount of $2,000. In the event you are able to post that bond and secure your release, you do need to go to that hearing on May 1st. If you are still in custody on May 1st, you will be transported. All right, go ahead, step to the left. Officer has your paperwork. Jenny Villarreal, and then Randy Joe.
No.
Hello. All right, ma'am, go ahead, state your name.
Jenny Villarreal,
And Ms. Villarreal, what is your date of birth?
8/15/1993.
Thank you. All right, ma'am, you are here because the Maricopa County Superior Court issued a warrant for your arrest based upon allegations that you violated your probation in your case CR 2022-006266. In that matter, I am appointing you an attorney, and I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in that matter in the amount of $500. In the event you are able to post that bond and secure your release, I am reminding you, because you are on probation, you would need to contact your probation officer within 72 hours of your release. You also need to go to those hearings on April 30th. If you are still in custody on April 30th, you will be transported, okay? All right, go ahead, step to the left. Officer has your paperwork.
So I could call her to see if I have a hold, right?
I'm sorry, what?
I could call my probation officer to see if I have a hold before posting bond?
I do not know if you have a hold or not. You can ask officers if they are, detention officers, if they're aware of a hold. They're telling me they're not.
So I could post bond?
So what we're telling you is these are the cases that we are aware of. That doesn't mean that there's not something that we don't know. As a matter of fact, the only thing that you're in front of me on is this one probation violation warrant. So I don't know if there are any warrants or other reasons to hold you at this time.
Okay.
All right, go ahead, step left. Randy Joe, please. And then Alder Hinojos. All right, sir, go ahead, state your name.
Randy Joe,
And Mr. Joe, what is your date of birth?
9/1894, Your Honor.
Thank you. All right, sir, you are here because the grand jury in Maricopa County issued a warrant for your arrest based upon allegations that on or about May 6th of 24, you committed the offense of aggravated assault, a Class 3 felony. There are 2 counts of that, and 1 count of disorderly conduct, a Class 6 felony. In that matter, I am appointing you an attorney, and I am setting a hearing on May 1st at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your matter in the amount of $800. In the event you are able to post that bond and secure your release, you're not having any contact with any alleged victim. You're not possess any weapons, no drugs without a valid prescription, and no alcohol. You're also going to need to go to that hearing on May 1st. If you are still in custody on May 1st, you will be transported, okay?
Okay, Your Honor, I
Yes,
do
sir.
live out of state. I live in New Mexico, and I do have responsibilities back home. Is there any way you can work with me with my bond? To feel like,
So, no. At this point, because you do have these charges pending against you in Maricopa, part of my release order is that you stay in Arizona. You are able to readdress this with the judge on May 1st, but at least at this point, I am going to require that you stay in Arizona. Okay, go ahead, step to the left. Alder Hinojos, please, and then LaChauncey Bruce. All right, sir, go ahead and state your name.
Lady Nojos, 12/20/1994.
Wait, you do the date, please state your date of birth slower.
12/20/1994.
Thank you. All right, sir. You are here because, I'm going to pull up your warrant. Because the Maricopa County Superior Court issued a warrant for your arrest in a direct complaint matter. That direct complaint alleges that on or about September 8th of 25, you committed the offense of possession or use of narcotic drugs, a Class 4 felony, and driving or actual physical control while under the influence of intoxicating liquor or drugs, a Class 1 misdemeanor. In that matter, I am appointing you an attorney, and I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
All right, then based upon your promise to appear, I'm going to go ahead and release you to pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates. I'm going to back up and ask you a question, and I should have done this before. Are you in custody on a different case?
Yes.
Okay. So give me just a second. And I apologize for missing that previously. Okay. All right, you, all right, let me back up. All right, I am appointing you an attorney. In your matter, I am setting hearings, this is going to be the new part. I am setting hearings on April 30th at 8:30 and May 4th at 8:30. Both of those are going to be in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $50. I am doing this in an attempt to give you credit for time in custody. If you're going to be in custody anyway, this is an effort to get you credit for that, okay?
Thank you.
All right. In the event you are able to post your bonds and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring and alcohol and drug testing. No weapons, no drugs without a valid prescription, and no alcohol. Do you have any questions?
No, ma'am.
All right, so we do need to reprint that. So if you go ahead and have a seat, we'll get it brought out to you, okay?
Thank you.
All right, Bruce LaChauncey, please, and then Mercedes Willis. All right, sir, go ahead, state your name.
LaChauncey Bruce,
And Mr. Bruce, what is your date of birth?
7/26/1980.
Thank you. All right, sir. You are here because you were arrested yesterday on charges of criminal trespass in the first degree, a Class 6 felony. I did find probable cause for that. I am appointing you an attorney. I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
Right, and based upon your promise to appear, I'm going to go ahead and release you this morning to pretrial services. Pretrial services will do things like remind you of your upcoming hearing date. You are not to return to the scene of the alleged crime or have any contact with any alleged complainant or witness, okay? All right, full release conditions are in your paperwork. If you go ahead, step left, officer, I'll have those for you. Mercedes Willis, please, and then Kelvin Jimenez Espericueta. All right, Ms. Willis, go ahead, state your name.
Mercedes Willis,
And Ms. Willis, what is your date of birth?
05/26/2000.
Thank you. All right, ma'am, you are here because you were arrested yesterday on charges of disorderly conduct, fighting a Class 1 misdemeanor, and assault Class 2 misdemeanor. I did find probable cause for both of those. Based on the nature of those charges, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain an attorney at your own expense to represent you. I am setting a hearing on May 13th at 1 p.m. in the Goodyear Municipal Court. Will you go to that? Is that a yes?
Yes.
Okay. And based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. Not to have any contact with the alleged victim. You may not reside at the same location as any alleged victim, or go to the alleged victim's residence, even if you are an owner or renter of the residence. If you currently reside with any alleged victim, you must find an alternative residence. You can arrange for one civil standby with law enforcement to collect any essential belongings. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're also going to need to obey the terms of any order of protection or injunction against harassment that has been issued or may be issued, okay?
Okay.
All right, go ahead, step to the left. Officer has your paperwork. All right, Kelvin Jimenez. And then Charles Sanchez. All right, sir, go ahead, state your name.
Kelvin Espericueta Jimenez,
And what is your date of birth?
March 29, 2000, ma'am.
Thank you. All right, sir, you are here because you were arrested yesterday on charges of possession of narcotic drugs, a class 4 felony. I did find probable cause for that. I am appointing you an attorney. I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to those hearings. If you don't go to those hearings, warrants may issue for your arrest, okay?
Yes, ma'am.
All right, go ahead, step left, officer. How's your
Thank you,
paperwork?
appreciate it.
Charles Sanchez, please, and then Zachariah Long, and after Mr. Long, we're going to take a break. All right, Mr. Sanchez, go ahead, state your name.
Charles Sanchez, 12/30/1994.
Thank you. All right, sir. You are here because you were arrested yesterday on charges of assault, class 1 misdemeanor, and disorderly conduct fighting, a class 1 misdemeanor. I did find probable cause for both of those. I am appointing you an attorney. I'm going to ask you a question based on your striped top. Are you in custody on any other charges?
No.
Okay. I am setting a hearing on May 27th at 8:30 in the Surprise Municipal Court. Will you go to that?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. Yes, sir.
What if she decides to move? Because I don't have any family here. I'm all by myself. Her entire family's here. She's willing to move. Am I able to go back to my residency that I just moved to from Florida 2 months ago? Or am I going to be in the street? Because I don't have anybody here or nowhere to go. She's willing to leave the house. Her mom lives across the street. She has 100 family members. She has a lot of places to go, more than 10 homes. And I just moved to Arizona a month and a half ago. Now, we've gone through this before in Florida.
Okay. So I am looking at the allegations in the Form 4 based upon the information in the Form 4. I understand your situation is difficult. However, looking at the information in the Form 4, I do have concerns about victim safety. So I'm going to leave my order as it is. You're not to return to the scene of the alleged crime. You're not to have any contact with any alleged victim, complainant, or witness. You're not to reside at the same location as any alleged victim or go to the alleged victim's residence, even if you are an owner or renter of the residence. If you currently reside with any alleged victim, you must find an alternative residence. You can arrange for one civil standby with law enforcement to collect any essential belongings. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're also going to need to obey the terms of any order of protection or injunction against harassment that has been issued or may be issued. All right, go ahead, step to left. Officer has your paperwork. Zachariah Long, please. All right, Mr. Long, go ahead, state your name.
Zachariah Long,
And Mr. Long, what is your date of birth?
5/19/05.
Thank you. All right, sir, you are here because you were arrested on charges of trafficking in stolen property, a Class 3 felony, and burglary in the 3rd degree, a Class 4 felony. I did find probable cause for both of those. I'm appointing you an attorney. I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to those hearings. If you don't go to those hearings, warrants may issue for your arrest, okay?
Yes, ma'am.
You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness, all right?
Yes, ma'am.
All right, go ahead,
All
step
right,
to left.
thank you. Have a good morning.
All right. All right, Sean Gilbert, please, and then Johannes O'Neill. All right, Mr. Gilbert, go ahead, state your name.
Sean Gilbert, 31474.
Thank you. All right, sir, you are here because the Maricopa County Superior Court issued warrants for your arrest based upon allegations that you violated your probation in your cases CR 2022-138911 and CR 2022-138910. In both of those matters, I am appointing you an attorney, and in both of those matters, I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
All right, then based upon your promise to appear, I'm going to go ahead and release you on your own recognizance in both of those matters. Now, because you are on probation, you will need to contact your probation officer within 72 hours of your release, okay?
Okay.
You also need to go to those hearings. If you don't go to those hearings, warrants may issue for your arrest.
Okay.
All right, go ahead, step to the left. Officer has your paperwork. All right, Johannes O'Neill, please, and then Larry Roy. All right, Mr. O'Neill, go ahead, say your name.
Johannes O'Neill,
And Mr. O'Neill, what is your date of birth?
01/21/86.
Thank you. All right, sir. You are here because you were arrested yesterday on charges of burglary in the third degree, a class 4 felony. I did find probable cause for that. I am appointing you an attorney. I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to those hearings. If you don't go to those hearings, warrants may issue for your arrest. Now, you are also here because you are currently on probation, and your case is CR 2021-101162, CR 2022-000236, CR 2024-115254, and CR 2021-123595. In each of those probation cases, your new charges for which you were arrested yesterday would constitute an alleged Term 1 violation in each of those probation matters. In each of those probation matters, I am appointing you an attorney, and I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. Will you go to those?
Yes, I will.
All right, then based upon your promise to appear, I'm going to go ahead and release you on your own recognizance in your 4 probation cases as well. Now, you do need to go to all your hearings. If you don't go to your hearings, warrants may issue for your arrest. Now, you are also on probation, so you're going to need to contact your probation officer within 72 hours of your release, okay?
Mm-hmm.
All right, go ahead, step to the left. Officer has your paperwork. Larry Roy, please. Hello, sir. Did they give you that big white card?
Yeah.
Okay. All right. All right, go ahead, state your name.
Larry Roy,
And Mr. Roy, what is your date of birth?
7/31/92.
All right, sir. You are here because California issued a warrant for your arrest. California wants you back on its warrant. Before court, you were given some paperwork to review on a big white laminated card. Did you read that paperwork?
The best that I can.
Okay. Do you need more time to review that paperwork?
No, am I just here just off of absconding or what?
So the state of California issued a warrant for your arrest based upon allegations that you violated your California parole. You have been arrested in Arizona on that warrant, and this is the extradition. This is the start of the extradition proceeding to get you back to California.
Okay. Do I have any pending charges from California? Do I have anything additional?
I have no idea. The only thing I have in front of me, I don't even know if you have any other Arizona charges. The only thing I have in front of me this morning is this one warrant from California about the parole violations.
Mm-hmm.
All right. As I stated, you have a warrant from the state of California. You have a choice to make at this time. You can choose to waive your right to an extradition hearing and be sent back to California within 30 days, or you can demand an extradition hearing and that a governor's warrant be signed by the governors of both states, that's California and Arizona, before you are sent back to the state of California. If you choose to waive your right to an extradition hearing, you would be held non-bondable in Maricopa County Jail for a period of up to 30 days to allow time for California to come for you. That 30 days would start tomorrow, as long as you do not have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, the 30-day period would not start until those charges are resolved. If you choose to have an extradition hearing, I will set your hearing for May 4th at 1:30 in the downtown Maricopa County Superior Court. I cannot appoint an attorney to represent you because extradition matters are civil in nature, but you would have the right to hire a lawyer at your expense if you choose. You would not be entitled to bail because the arrest warrant is for a parole violation. A governor's warrant signed by the governors of both states is required to extradite you to California. That process could take up to 90 days. So, do you want to waive your right to an extradition hearing and be held non-bondable here in Maricopa County for a period of up to 30 days to allow California time to come for you, or do you want to retain that extradition hearing on May 4th at 1:30 and start the governor's process going? That process could take up to 90 days. Now, it's a lot to think about, and you will be offered this choice again on May 4th if you decide to keep that extradition hearing.
I don't understand the second option.
So the second option is, so if you waive your right to an extradition hearing, that's option one, right? You will be held non-bondable here in Maricopa County Jail for a period of up to 30 days to allow California time to come for you. The second option is to retain that extradition hearing on May 4th. You'll see a judge on May 4th, and that will start the governor's warrant process going. That process could take up to 90 days because the governor...
What is a warrant process? I'm sorry to cut you off. I don't know exactly.
So in order to extradite you to California, a warrant signed by the governors, a warrant must be signed by the governors of both states, California and Arizona, in order to extradite you to California. That process could take up to 90 days.
Okay, the part that I'm confused about is just the reason of why anyone does the second option. I don't know how that would benefit me if that was like a choice that I want to make. I understand the first one, just get it over with, do the way they just sit here 30. If they come, they come. But I don't understand the purpose if I want to make the decision. That's what I'm trying to say.
Okay. If you're not, I don't know, honestly, I don't know why. Some people choose differently, and they have reasons for doing it when they do. I can't provide you legal advice.
No, not legal advice. I'm trying to see the purpose, basically. Like, so both parties have to sign.
So in order to, unless you waive, right? If you waive, that's option one. If you don't waive, that's option two. You get your extradition hearing, and in order to get you extradited back to California, the governors of both California and Arizona have to sign a governor's warrant to get you extradited to California. That process could take up to 90 days. Now, in your case, because of the nature of your warrant, you would be held non-bondable during that time.
Mm-hmm. Okay. So one of them's for 30 days, and the other one is waiting for both governors to get me out of here?
To sign. So you would go to the hearing, the extradition hearing on May 4th. You'll talk to a judge there. She'll offer you these same choices, by the way. So some people like to think about it. So she'll offer you these same choices on May 4th. If you don't waive, your matter will get routed through the governor's warrant process. That's the process where the governors of both Arizona and California have to sign in order to get you extradited to California.
I'm not trying to take up time.
No.
Sorry about disrespect, but I'm confused on why would California have to sign for an extradite if they're already extraditing me. I don't. Because it sounds like one phase gives me 30 days to sit here, and another one, it sounds like, do you want to sit here 90 or do you want to sit here 30? I'm asking for legal advice. I just still don't understand. Like, if I want to exercise that, I just don't see, like, so if the papers don't get signed or something like that within 90 days, am I supposed to be getting released or?
Well, so
It could take up to 90 days.
So if you waive
Uh-huh.
and you agree to be held non-bondable here in Maricopa County for a period of up to 30 days, if California doesn't come to get you in 30 days, they can ask for a few more days, but it's basically 30 days, then you will be released.
Okay.
And different people have different, are in different situations because your warrant, so for probation and parole warrants, I am obligated to hold those people non-bondable. But different people, some people are on arrest warrants. And some people are actually, so those are bondable warrants. So they may choose to go that route. They may want to talk to the judge on May 4th about their warrant. And so different people have different situations.
So is it guaranteed that I get picked up in 30 days, or is there?
No, it's not.
Okay. So there's some type of cases where.
So if California doesn't pick you up in 30, if you waive, if California doesn't pick you up in 30 days, then you would be released.
Okay, I'll do the 30.
You'll do the 30?
Yeah.
All right. All right. We are going to go through some questions now. If you've ever done a plea agreement, this is a lot like that, okay? All right, I understand at this point you do want to sign the waiver of extradition. I need to ask you some questions as I am making a record of this proceeding. Did you read the waiver of extradition paperwork?
No.
Do you understand that you do not have to sign the paperwork? You have to answer out loud.
Yes.
Okay. Do you understand that you have the right to an extradition hearing?
Yes.
Okay. Do you understand that you have the right to hire a lawyer at your own expense?
Yes.
Okay. Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states, California and Arizona, before you are returned to California?
Yes.
Okay.
If I were to take that option, if both parties aren't signed by 90 days, they have to release me? Is that how that goes? Like what's the...
So that process could take up to 90 days. I don't know what happens, honestly, if the warrants aren't signed within 90 days.
Yeah, so that's why it kind of enables, it doesn't help me make the right choice when I don't know the background on it.
So if you are unsure, I can go ahead and set your extradition, your hearing for May 4th at 1:30, and you can think about it, and you can, a judge on May 4th will have more information.
But if I do the 30, my time starts today.
Your time would start tomorrow, as long as you don't have any local charges pending against you here in Arizona, and I don't know that.
Is it a difference? It's like, if, do they have to, like, because I know I had somebody, like, it's like very old, it's like 10 years or something like that. I think he said, like, driving a suspended license. He didn't book me in on it or something like that. He's like, I'm not booking you on that. It's like, they're not going to pick that up. So I don't know. How does that work?
I don't know.
Okay. So even though he don't book you on my charges, I can still be, because they're misdemeanors or whatever the case. So,
So all of these things, may go into the mix, I just don't know.
I would know on the 4th, though.
You can talk to the judge on the 4th, the judge on the 4th should have some more information.
Okay, yeah, I'll just do the 30, whatever, the waive.
Okay, then you won't get that extradition hearing on the 4th.
Okay, that's fine, man. Yeah, that's fine.
Okay, now which do you want, now you've confused me. Which one do you want to do?
I'm rather the 30 days.
Okay.
Waive my stuff for 30 days.
All right. All right. Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states, that's Arizona and California, before you are returned to California?
Yes.
Okay.
How would I know about if I have anything pending?
If you have local charges pending,
How would I know that?
I don't know that. And officers, I mean, they have limited information. We don't know other counties. We're honestly, despite the fact we're all living in the computer age, we're really pretty limited about what information we know.
Okay. Okay, thank you. That's it.
And sir, I mean, really, if you want to think about it, to talk to the judge on the 4th.
No, it's okay. I just want to get my time running.
Okay. All right. Do you understand that in this case you would not have the right to bail because it is a probation violation warrant?
Yeah. Well, I thought it was parole.
Parole. I apologize.
Okay.
Parole. Okay. Do you understand that you do not have the right to bail in this case because it is a parole violation warrant?
Yes.
Okay. Do you want to give up those rights and sign the paperwork?
Yeah.
Okay. Has anyone threatened you or promised you anything to get you to sign the paperwork?
No.
Okay. Have you had any drugs, alcohol, or medication within the last 24 hours?
No.
I find that you knowingly, intelligently, and voluntarily are signing the waiver, and I'm also signing it. I am directing the sheriff's office to notify California that you are ready to return. California will have 30 days from tomorrow to pick you up unless there are local charges pending. If there are local charges pending, the 30 days will not start until the conclusion of that case. Do you have any questions?
Last question is, so after the 30, but I can still be held additional?
No. After the 30, you will be released if California does not come for you. They can request a few days worth of extension.
Okay. All right, thank you.
Okay. All right, wait, you've got to sign things, come back. Okay, hold on just a second, let me update my piece, and then it's going to be your turn. Don't sing it, I'll let you know. Oh. Okay, hold on. Can you go ahead and sign, please? Can you go ahead and sign it? All right, you want to sign the next one? Okay, thank you. I'll sign for paper. All right, thank you, sir. Good luck to you.
You guys are charged.
Yeah, this paperwork's printing right now.
And officers, we're clearing.
Yeah.
Oh, I'm sorry. Looks good to me. Thank you. All right, John Nelson, please.
Morning,
Good morning, sir. All right, go ahead, state your name.
John Nelson,
Mr. Nelson, what is your date of birth?
12/24/68.
That was 12/24/68?
Yes, ma'am.
All right, sir. You are here because state of North Carolina has issued warrants for your arrest. Were you given some paperwork on a big white laminated card?
Yeah.
All right, we're going to go through that.
Well, I'm gonna go ahead and,
Huh?
I'm gonna go ahead and ride, see, the 160, 90 days.
Uh-huh.
I'm gonna wait for 30 days for him to come get me.
Okay. Well, it sounds like you have made up your mind then. Okay, so, but we still need to go through this information, just to make sure that I've done everything that I need to do. But I don't want you to, but I'm going to do that, but I don't want you to think I didn't listen to you, because I did, but I just need to do, I need to go through my, my information, okay? All right. All right, sir. A warrant for your arrest has been issued by the state of, or warrants for your arrest have been issued by the state of North Carolina. North Carolina wants you back on these warrants. Before court, you were given some paperwork on a big white laminated card, and you said you read that paperwork, right?
I read as best I could. I can't understand stuff because of the strokes.
Okay. All right, we'll go through it, the information. I'll go through that information again, and then if you have questions, I'll answer what I can, okay?
Okay.
All right. As I stated, you have warrants from the state of North Carolina. You have a choice to make at this time. You can choose to waive your right to an extradition hearing and be sent back to North Carolina within 30 days. Or you can demand an extradition hearing and that a governor's warrant be signed by the governors of both states, that's Arizona and North Carolina, before you are sent back to the state of North Carolina. If you choose to waive your right to an extradition hearing, you would be held non-bondable in Maricopa County Jail for a period of up to 30 days to allow time for North Carolina to come for you. That 30 days would start tomorrow as long as you do not have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, the 30-day period would not start until those charges are resolved. If you choose to have an extradition hearing, I will set your hearing for May 4th at 1:30 p.m. I cannot appoint an attorney to represent you because extradition matters are civil in nature, but you would have the right to hire a lawyer at your own expense if you choose. Now, you do have 2 warrants out of the state of Arizona, out of the state of North Carolina. Your first warrant is based upon allegations that you violated your North Carolina probation. In that matter, you are not entitled to bail. Your second warrant out of the state of North Carolina is based upon underlying charges that you failed to report your new address as you were required to do as a sex offender, okay?
Right.
All right, now in the second case for failure to report, or based upon the charges of failing to report your new address, in that matter, you are entitled to bail. And bail in that case would be set in the amount of a cash-only appearance bond in the amount of $25,000.
Oh,
All right? If you are unable to post the $25,000, you would be held in custody until another judge modifies your bail. However, as I mentioned, for the probation violation warrant, I am holding you non-bondable in that matter. A governor's warrant signed by the governors of both states is required to extradite you to North Carolina. That process could take up to 90 days. So at this point, and I know you said it at the beginning, but I'm going to ask you again. Do you want to waive your right to an extradition hearing and be held non-bondable here in Maricopa County Jail for a period of up to 30 days, or do you want to start the governor's warrant process going?
wait for 30 days,
Okay, you waive it and stay for 30 days?
30 days,
Okay, in both cases, on both warrants?
yes.
Okay.
That would be one 30 days, I wouldn't be the 60 days, right?
It is, yes, sir, it would just be the 130 days. And that was a good question, but yes, just the one 30 days. Okay. Now, they can ask for a few days extension at the end, but it is basically 30 days, okay?
Okay.
All right. I understand at this time you do want to sign the waiver of extradition. I need to ask you some questions as I am making a record of this proceeding. Did you read the waiver of extradition paperwork? That big white laminated card?
Yeah.
Do you understand that you do not have to sign the paperwork? Do you understand that you do not have to sign the waiver?
Yeah.
Okay. Do you understand that you have the right to an extradition hearing?
Yes.
Do you understand that you have the right to hire a lawyer at your own expense?
Yeah.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before you are returned to North Carolina?
Yeah.
Do you understand that you have the right to bail in connection with the warrant for your failure to report new address charge warrant?
Right.
And do you understand that for the probation violation warrant, you are not entitled to bail?
Right.
Do you want to give up those rights and sign the paperwork?
Yeah.
Okay. Has anyone threatened you or promised you anything to get you to sign the paperwork?
No.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No.
I find that you knowingly, intelligently, and voluntarily are signing the waivers, and I am also signing them. I am directing the sheriff's office to notify North Carolina that you are ready to return. North Carolina will have 30 days from tomorrow to pick you up unless there are local charges pending here in Arizona. If there are local Arizona charges pending, the 30 days will not start until the conclusion of that case. Do you have any questions?
Yeah.
Okay. So give me just a minute to update my paperwork, and then it's going to be your turn.
Okay. I can speak to her.
Yeah, we're almost done. Let's we get out of here. We don't have any water in here. Wait a minute. We'll go over here and just grab you a couple things.
All right.
All right, sir. I think we should be ready for you. Go ahead and sign, please.
Sign one more time, please. Let's put the first one, do that before, and then I'll have you do it again for that. Okay, go ahead and sign, please.
So good, thank you.
Then sign one more time, please. Okay, thank you, I'll get you the paper.
All right, are we ready? Can we go to the next guy? Do you need another minute?
Yeah, I'm ready to go on to the next one. Here's the paperwork.
Okay. Jesse Pete, please.
Get him some. Get him.
Yeah,
It's open. Yeah.
All right, Mr. Pete, yes, there you go. All right, Mr. Pete, go ahead and state your name.
Jesse Edward Pete,
And Mr. Pete, what is your date of birth?
4869,
I'm sorry, one more.
4869.
Thank you, sir. All right, sir, you are here because you were arrested yesterday on charges of failure to register as a sex offender, a Class 4 felony, and failure to update and confirm your personal information as a sex offender, a Class 6 felony, and indecent exposure, a Class 1 misdemeanor. I did find probable cause for all of those. I am appointing you an attorney. I am setting hearings on April 30th at 8:30 and May 4th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $25,000. In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions, including electronic monitoring. You're not to return to the scene of the alleged crime or have any contact with any alleged victim, complainant, or witness. All right, sir.
That's something I want to say.
All right, sir.
I'm saying this. This is what I'm saying. I'm saying to you, I'm telling you personally this. All of this stuff right here, this court hearing, those charges, all of them, they're, and I want this on the record, it's all bullshit. Now, I was told by somebody from the Maricopa County, I went to the Phoenix, to the mayor's office. They told me I did not have to register because they wanted all this stuff to end. And then they told me, she called the governor's office. The governor's office said that she told the mayor's office that they could do away with this case, the original case, and any other cases, because they didn't want me to be going to court anymore. They didn't want this stuff, because it's an embarrassment to everybody, to the state, to me, and everybody. So they just wanted it to go away. However they did it. So I was informed, this new case is completely, I'm stating for me, bullshit. Now, I wish I could tell you so you could understand. Now, I don't know if you know about, if you deal with Satan and all this other stuff, but this is a demonic state, and that's what I deal with. I deal, because I'm Satan.
Okay.
So just let me finish. Let me finish what I'm going to say. You can do it.
Will you please wrap it up, sir?
So I want to state this for the record. This is me, Jesse EP. I am not responsible for any of this stuff. All this stuff is done by entities that's in my body.
Okay.
So let me say what it is. For the record, these people do exist, and they are in my body, and I am them. I'm God, I'm Jesus Christ, and I am Satan, and I'm also God's spirit. All these things in my body, but they do what they want to do, and they use my body. Now, I have no control when they do what they do.
Okay. All right, sir. So I've given you time, sir. I am going to go ahead and leave that bond set. Officers are going to help you out if you need it. Thank you. All right, Aaron Bayman, please, and then Alejandro Tavar. All right, sir, go ahead, state your name.
Aaron Bayman,
Mr. Bayman, what is your date of birth?
6/11/84.
Thank you. All right, sir, you are here because the grand jury in Maricopa County issued a warrant for your arrest based upon allegations that on or about September 16th of 25, you committed the offense of failure to register as a sex offender, a Class 4 felony. In that matter, I am appointing you an attorney, and I am setting a hearing on May 1st at 8:30 in the downtown Maricopa County Superior Court. Pursuant to that grand jury arrest warrant, I am setting a secured appearance bond in the amount of $1,500. In the event you are able to post that bond and secure your release, you do need to go to that hearing on May 1st, okay?
Okay, is that cash only or?
It's a secured appearance bond, so you can work with a bond company to post that.
Okay, 1,500. Okay, thank you.
Go ahead, step to left.
Yeah.
All right. Alejandro Tavar, please. Was that bonging? Interpreter, this is Commissioner Campbell. Can you hear me?
Yes. Hello.
Hello. All right. Interpreter, we have Alejandro Tavar here.
Good morning, señoría.
Good morning, sir. Interpreter, will you please introduce yourself to Mr. Tavar and let him know about your services?
Hola, señor Tobar. Mi nombre es Carlos. Voy a ser el intérprete o traductor en la conversación que usted tendrá con la dama.
Good. Sí. Es good.
¿Puede hablar en español usted, señor?
Sí. Sí. Más español.
All right, sir. Go ahead, state your name.
No, he understands. Señor, diga su nombre.
Alejandro Tovar Castellanos.
Alejandro Tovar Castellanos.
Sí.
And Mr. Tavar, what is your date of birth?
Señor Tovar, ¿cuál es su fecha de nacimiento?
El 11 de enero de 1938.
January 11, 1938.
Exacto.
All right, sir. You are here because the grand jury in Maricopa County issued a warrant for your arrest.
Señor, usted está aquí el día de hoy porque el condado de Maricopa emitió una orden para su arresto.
That warrant was based upon charges that you committed the following offenses.
Esa orden de arresto es basada en los cargos que se le han imputado y se le van a mencionar a continuación.
8 counts of sexual assault, class 2 felonies.
8 a cuentas de asalto sexual, que es un delito clase 2.
1 count of attempted sexual assault, a class 3 felony.
Una cuenta o un cargo de intento de agresión sexual, lo cual es un delito categoría número 3.
And 2 counts of sexual abuse, class 5 felonies.
Y 2 cargos de abuso sexual, que es un delito categoría 5.
In that matter, I am appointing you an attorney, and I am setting a hearing on May 1st at 8:30 in the downtown Maricopa County Superior Court.
En base a eso, le estoy agendando o nombrando a un abogado y voy a estar agendando una audiencia el 1 de mayo a las 8:30 de la mañana en la corte del centro del pueblo del condado de Maricopa, la corte superior del condado de Maricopa.
In this first grand jury matter, I am setting a secured appearance bond in the amount of $500,000.
Muy bien, en base a estos cargos, yo estaré agendando una fianza que usted tendría que pagar de seguridad por la cantidad de $500,000.
In the event you are able to post that bond and secure your release, you would be subject to certain pretrial release conditions.
En caso de que usted pague esta fianza, usted tiene que cumplir con algunas condiciones antes de su juicio.
Those release conditions include electronic monitoring. You're also not to have any contact with any alleged victim.
Muy bien. Alguna de las condiciones es que usted tendría que someterse a monitoreo electrónico, así como también tiene que evitar cualquier tipo de contacto con las alegadas víctimas.
Now, Mr. Tovar, you are also here because because the grand jury in Maricopa County issued a second warrant for your arrest.
Muy bien. Usted también está aquí el día de hoy, ya que el condado de Maricopa ya había emitido un segundo notificación o petición de su arresto.
That second warrant is based upon allegations that you committed 8 counts of sexual assault, class 2 felonies.
Esa segunda orden de arresto es debido a que se le han imputado cargos, o se ha alegado cargos en contra suya, por 8 cuentas de abuso sexual o de agresión sexual, lo cual es un delito categoría número 2.
And 3 counts of sexual abuse, class 5 felonies.
Y 3 cuentas de abuso sexual, lo cual es un delito categoría número 5.
In this second matter, I am also appointing you an attorney, and I am setting a hearing again on May 1st at 8:30 in the downtown Maricopa County Superior Court.
Muy bien, para este también le estaré agendando o nombrando a un abogado y estaré poniendo una audiencia que sería para la misma fecha, mayo 1 a las 8:30 de la mañana en la Corte Superior del Condado de Maricopa.
In the second matter, I'm also setting a secured appearance bond in the amount of $500,000.
En estos cargos también estaré agendando o pautándole una fianza de $500,000.
In the event you are able to post those bonds and secure your release, again, you would be subject to certain pretrial release conditions.
En el caso de que usted pueda pagar esa fianza, recuerde nuevamente, tiene que cumplir con ciertas condiciones antes de su juicio.
Those release conditions include electronic monitoring. You're also not to have any contact with any alleged victim.
Nuevamente, tiene que someterse a monitoreo electrónico y no puede mantener el contacto con ninguna de las alegadas víctimas.
All right, sir. If you go ahead, step to left, officer will have your paperwork for you.
Si miras hacia la izquierda o si va hacia la izquierda, el oficial le estará dando sus documentos.
¿Puedo hablar?
Can I speak?
¿Puedo hablar? ¿Puedo hablar?
Yes.
Can I speak?
Yes.
Adelante.
Yes,
Okay.
I am going to remind you, sir, before you begin, that you do have the right to remain silent. Anything you say could be used against you.
Claro, puede hablar.
Debo-
Simplemente quiero recordar que cualquier cosa que usted diga puede ser utilizada en su contra y usted tiene el derecho a permanecer en silencio.
Bueno, yo puedo mantener silencio porque los hechos están alterados, sumamente alterados. Las personas no son hijas mías. Las personas que mantuvieron esa voz para poder decir que yo estaba haciendo eso, querían quedarse con el negocio, porque aquí cerca tenían mi negocio. Y ahora están gozándose del retiro, que ya se lo terminaron casi.
All right, sir, I'm going to ask you to stop so I can get a translation.
Sí, deténgase para poder continuar con la interpretación. Yes, I wanted to speak because I just wanted to state that what really happened has been grossly altered. The people that said that or charged this against me, they aren't my family, they aren't my daughters. Those people want to take my business away from me because I have a business nearby. They want to get it for themselves.
Eso es un momento. Eso venía porque cuando me junté con la madre, yo no sabía que sus hijas eran drogadictas y todo. Cuando me junté con la madre, ella, la más chiquita, dijo, voy a hacer todo lo posible por mover todo para separarlos a ustedes. Y eso pasó. Bueno, ella ya entregó su cuerpo.
Okay, so I'm going to pause you again. Interpreter, will you please interpret?
Yes, so what happened in reality was that when I got with the mother of those girls, she said one of the girls, the youngest one, said that she would do anything in her power to separate us.
Okay. All right, sir. I'm going to stop you. I have appointed you an attorney in both cases, and any defenses you may have, you're going to need to talk to your attorney about. Okay?
Muy bien, señor. Verdad, le voy a detener porque ya yo le agendé a un abogado y cualquier defensa que usted tenga en cuanto a este caso tiene que discutirla con su abogado, primero que nada.
Como no, hasta el presidente puede incluir, porque yo era el líder. Aquí en el Distrito 7, las maestras me conocen, yo mantenía un estatus en el cual era querido por las madres, por los niños, pero ella miraba todo el eje del negocio, la gente cómo llegaba, ¿sí? Y hizo ese movimiento en contra mí hasta el canal de televisión.
Okay, so I'm going to stop you. Interpreter, one more time.
Yeah, so I remain a good standing on the community, and those girls were watching whatever I do with my business and everything just to keep it up for themselves.
Okay. All right, sir, again, I understand you have defenses. Talk to your attorney about those. Go ahead, step to the left. Officer has your paperwork.
Entiendo que usted tiene, ¿verdad?, su defensa, pero hable con su abogado. Ahora, por favor, vaya donde el oficial
Perfecto.
para que
Sí.
le dé sus documentos.
Sí, me necesito defenderme. Necesito defenderme. La madre, pues ya murió.
Señor, no es con ella.
Ya.
No es con ella que se tiene que defender.
No, ahora de papeles no. Pero lo que dicen sí. Porque la madre miraba cosas. Miraba cosas, decía que 10 mujeres se asaltaban por la ventana. Todas las noches conmigo. Eso era mentira. Y ellos se llevaban con la madre. Y yo le daba de $1,000 para arriba.
Entiendo lo que usted está hablando, señor.
$1,000 para arriba, siempre que llegaba.
Mr. Tavar.
Es injusto.
Mr. Tavar, at this point I need you to step to the left. Officer will have your paperwork for you.
Entonces se cree más la mentira.
Señor, ahora mismo necesito que se detenga y que recoja el documento que el oficial tiene para usted.
Está bien. Sí.
All right.
No puedo caminar.
I can't walk.
All right, interpreter, thank you so much for your assistance. We really appreciated it. You have a good morning.
Yes, well, thank you for calling Lion Bridge Interpreter 4001, disconnecting. Goodbye.
Bye, thank you. All right, we do have 3 house calls this morning. Our first house call is Thomas Sellies. Mr. Sellies' date of birth is February 18th of 1986. Mr. Sellies is unable to be with us this morning because he is combative. Is that correct? All right, Mr. Sellies is here because he was arrested on charges of armed robbery, a Class 2 felony. I did find probable cause for that. I am appointing him an attorney. I am setting hearings on April 30th at 8:30 and May 4th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. His matter, I am setting a secured appearance bond in the amount of $75,000. In the event he is able to post that bond and secure his release, he would be subject to certain pretrial release conditions, including electronic monitoring. Now, our next house call is Flor Luna. Ms. Luna is unable to be with us this morning because she is unable to function for purposes of being in the court this morning. Ms. Luna is here because the Maricopa County Superior Court issued a warrant for her arrest in a direct complaint matter. That direct complaint alleges that she committed the offenses of possession or use of narcotic drugs, a Class 4 felony, possession or use of dangerous drugs, a Class 4 felony, and misconduct involving weapons, a Class 4 felony. In that matter, I am appointing her an attorney, and I am setting hearings on April 30th at 8:30 and May 4th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. In Ms. Luna's matter, I am setting a secured appearance bond in the amount of $2,500. And if I didn't, I should have said that Ms. Luna's date of birth is May 23rd of 1987. All right, our last house call is Bryce Jocelyn. Mr. Jocelyn's date of birth is 11/23 of 1986. Mr. Jocelyn is unable to be with us this morning because he is being disruptive. Mr. Jocelyn is here because he was arrested on 8 counts of organized retail theft, Class 4 felonies. I did find probable cause for those. I am appointing him an attorney. I am setting hearings on April 8th at 8:30 and May 8th at 8:30 and May 12th at 8:30, both in the downtown Maricopa County Superior Court, because my intention at this point is to release Mr. Jocelyn to pretrial services and require electronic monitoring. All right, in the event that anything changes after I talk to the House calls in-house, I will update my written recommendations or my written orders in those cases. And that does bring us to the end of our 2 a.m. initial appearance calendar. We're going to go ahead and stand adjourned until 5, and we are off the record.
gonna start on Monday. I'm gonna do it for a few months. I wanna travel. I wanna go shopping, I wanna travel.
All right.
I like clothes. I like clothes.
All right, thank you. May be seated. All right, good morning. My name is Commissioner Elizabeth Campbell, and this is the 5 a.m. initial appearance calendar for April 24th, 2026. Court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar. Persons appearing before this court are reminded that they have the right to remain silent and that anything they say could be used against them. Most of you have qualified for a court-appointed attorney. If you have not qualified for a court-appointed attorney, or even if you have, you may retain an attorney at your own expense to represent you. I will be calling you up individually. When your name is called, please proceed to the podium. At the conclusion of your matter, officers will have paperwork for you. That paperwork will contain my complete orders in your case. It will also contain the dates, times, and locations of your future hearings. All right. I now need to read your victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right. All right, we're going to go ahead and start this morning with Mario Gomez and then Rosie Lopez, please. All right, Mr. Gomez, go ahead and state your name.
Mario Cesar Gomez, Jr.,
And Mr. Gomez, what is your date of birth?
12/19/1989.
Thank you. All right, sir, you are here because you were arrested yesterday on charges of criminal trespass in the first degree, a Class 6 felony, and disobeying a court order, a Class 1 misdemeanor. I did find probable cause for both of those. I am appointing you an attorney. I am setting hearings on April 30th at 8:30, May 1st at 1:30 p.m., and May 4th at 8:30. All of those will be in the downtown Maricopa County Superior Court. Because you were on release in your case CR 2025-150313 on the date of offense for your new felony, for which I found probable cause, I am holding you non-bondable on your new felony charges. All right, go ahead, step to the left, officer has your paperwork.
Nothing to say. I can't say nothing on it.
If you, well, of course you may speak. I'm just going to remind you, I'm going to remind you of one thing, and then I'm going to provide a statement about another. You do have the right to remain silent. Anything you say could be used against you. Under Arizona law, if probable cause is found for a new felony while you are on release on a previous felony matter, I am obligated to hold you non-bondable. So I don't have discretion on that. Would you like to say something?
Yeah, I wasn't ever advised of the trespass on that place, and I've been at that place since I've been released the whole time. So it was news to me on that trespass.
Okay.
How I even got there.
All right. Go ahead, step to left, officer has your paperwork. Rosie Lopez, please, and then Joseph Esperance.
Good morning.
Good morning, ma'am. Go ahead, state your name.
Rosie Lopez,
And Ms. Lopez, what is your date of birth?
2684.
Thank you. All right, ma'am, you are here because the grand jury in Maricopa County issued a warrant for your arrest based upon allegations that on or about February 23rd of 2026, you committed the offense of organized retail theft, a Class 4 felony.
Okay.
In that matter, I am appointing you an attorney, and I am setting a hearing on May 1st at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in your matter in the amount of $7,500. In the event you are able to post that bond and secure your release, you're not to return to the scene of the alleged crime. You are also going to need to go to that hearing on May 1st. If you are still in custody on May 1st, you will be transported, okay?
Okay, thank you.
All right, go ahead, step to the left. Joseph L'Esperance, and then Joshua Estrada. All right, sir, go ahead, state your name.
Joseph Kenneth Lesperance, 526-1987.
Thank you. All right, sir. You are here because Maricopa County Superior Court issued a warrant for your arrest based upon your failure to appear in your matter CR 2024-139600. In that matter, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you. So I'm not making that decision again this morning. I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in this matter in the amount of $350. In the event you are able to post that bond and secure your release, I am reminding you, you are on probation. So you would need to contact your probation officer within 72 hours of your release. You also need to make sure you go to that hearing on the 30th. If you are still in custody on April 30th, you will be transported, okay? All right, go ahead, step to the left. Joshua Estrada, please, and then Omar Abdallah. All right, sir, go ahead, state your name.
Joshua Estrada,
And Mr. Estrada, what is your date of birth?
02/16/1999.
Thank you. All right, sir. You are here because the Maricopa County Superior Court issued a warrant for your arrest based upon your failure to appear in your matter CR 2022-00656. In that matter, the court should already have made a determination about whether or not you are entitled to have an attorney appointed for you. So I'm not making that decision again this morning. I am setting a hearing on April 30th at 8:30 in the downtown Maricopa County Superior Court. I'm also setting a secured appearance bond in your matter in the amount of $250. In the event you are able to post that bond and secure your release, I am reminding you, you are on probation, so you would need to contact your probation officer within 72 hours. You also need to go to that hearing on April 30th. If you are still in custody, you will be transported for the April 30th hearing, okay?
Okay, I got a quick question.
Yes, sir.
So the only way I can get off, I'll pay for the 250 bond?
It is a secured appearance bond, and yes, in order to secure your release, you would have to post bond.
Okay.
All right, go ahead, step to the left. Omar Abdallah, and then Monique Smith. All right, sir, go ahead, state your name.
Omar Abdallah,
And Mr. Abdallah, what is your date of birth?
April 24, 2002.
Okay, thank you. All right, I'm going to ask you a question. I'm seeing you on an Encanto Justice Court warrant and a Country Meadows Justice Court warrant. Are you in custody on anything else?
I was in custody for a criminal, but it already got dismissed.
It already got...
Yeah, it already got dismissed, okay. And I got a good relationship with my probation officer.
Okay.
So I'm not sure if I might get a bond.
Okay. You're going further than you need, than I need you to go right this minute. So I'm going to ask you a question. So the only thing holding him, are these two Justice Court cases?
Yes, ma'am.
Okay, give me just a second. right, sir, and I apologize, I didn't mean to cut you off, and I feel that I did. You provided me with the information I wanted and I was looking for between you and the detention officers. Do you have anything else that you would like to tell me?
Not at the moment, no.
Okay. All right. All right, we're going to go warrant by warrant because they're different courts. All right, sir. And did you tell me your birth date is April 24th of 2002?
Mm-hmm.
Okay. All right, sir. You are here because the Encanto Justice Court issued a warrant for your arrest. This is a post-adjudication warrant. It is dated June 10th of 25. This Encanto Justice Court warrant is based upon underlying charges from January of 23 of DUI. In that matter, I goofed. I need you to reprint number 3 again, and probably number 22. Hold on. In that matter, okay, sorry about that. All right, in that matter, due to the nature of those charges, you're not entitled to have me appoint an attorney for you in that case. However, you may, of course, retain an attorney at your own expense to represent you. Could you reprint them both so they're both showing that no order regarding counsel, which is what they should be? All right. In your Encanto Justice Court matter, I am setting a hearing on April 14th at 1:30 p.m. Will you go to that?
April 14th?
At 1:30 p.m. I'm sorry. Let me...
April 14th is...
and that is an excellent point. It's May 14th at 1:30 p.m.
Okay.
Will you go to that?
Yes.
All right. Then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to that hearing. If you don't go to that hearing, a warrant may issue for your arrest. All right. Now, your second case is a warrant out of Country Meadows Justice Court. This is also a post-adjudication warrant. This one was issued on July 15th of 25. The underlying charge here is a June 23 DUI charge. In this matter, as with the first, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain one at your own expense to represent you. I am setting a hearing on May 14th at 8:30 in the Country Meadows Justice Court. Will you go to that?
Yes.
All right, then based upon your promise to appear, I'm going to go ahead and release you in this matter on your own recognizance as well. You do need to go to your hearings. If you don't go to your hearings, warrants may issue for your arrest, okay?
Okay.
All right, officers should have your updated paperwork with your new information. If you go ahead, step to the left, she'll go ahead and give it to you.
Okay. I have one more question as well.
Yes, sir.
So even if I'm on probation, I could still be released, or do I have to contact my probation officer?
So,
I'm pretty sure she's already known.
Are you on Maricopa County probation?
Yes.
Okay. So, in general, if you're on Maricopa County probation, you do need to contact your probation officer within 72 hours of your release. I don't have that particular information as part of my stuff, but that is a typical probation term unless you are on intensive probation services, and then it is 24 hours.
Okay.
Okay?
Mm-hmm.
All right, go ahead, step to the left. Officer has your paperwork. Monique Smith and then Valerie Ruelas. All right, Ms. Smith, go ahead, state your name.
Monique B. Smith,
And Ms. Smith, what is your date of birth?
7/1984.
Say it one more time.
7/1984.
7 what?
1984.
So it's 7/19?
Mm-hmm.
Okay. Officers, have we confirmed that this is the Monique Smith that is the subject of this direct complaint? She's giving me a different birth date.
There's a different birth date located on our paperwork, but...
Okay, so
We got it wrong, as in when they first
Yeah, it could be
obtained her
input,
date of
input
birth,
wrong.
they probably input it as wrong.
okay, so this is the correct person?
This is correct.
Okay. All right, Ms. Smith. You are here because Maricopa County Superior Court issued a warrant for your arrest in a direct complaint matter. That direct complaint alleges that on or about December 20th of 23, you committed the offense of possession or use of dangerous drugs, a class 4 felony, and possession or use of drug paraphernalia. In that matter, I am appointing you an attorney, and I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
All right, then based on your promise to appear, I'm going to go ahead and release you this morning to pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates, okay? You do need to go to your hearing dates. If you don't go to your hearing dates, warrants may issue for your arrest.
Okay.
All right, go ahead, step to the left. Officer has your paperwork. Valerie Ruelas, please, and then Amina Cleaver-Bascom. All right, ma'am, go ahead, state your name.
Valerie Ruela,
And Ms. Ruelas, what is your date of birth?
08/04/2003.
Thank you. All right, ma'am. You are here because you were arrested yesterday on 3 counts of disorderly conduct, fighting, class 1 misdemeanors, and 1 count of driving with a suspended or revoked license, a class 1 misdemeanor. I did find probable cause for all of those. Due to the nature of those charges, you're not entitled to have me appoint an attorney for you this morning. However, you may, of course, retain a lawyer at your own expense to represent you. I am setting a hearing on May 12th at 2 p.m. in the Buckeye Municipal Court. Will you go to that?
Yes.
Then based upon your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You're not to return to the scene of the alleged crime. You're not to have any contact with any alleged victim. You may not reside at the same location as any alleged victim, nor go to the alleged victim's residence, even if you are an owner or renter of the residence. If you currently reside with any alleged victim, you must find an alternative residence. You are not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're also going to need to obey the terms of any order of protection or order against harassment that has been issued or may be issued, okay?
Okay.
All right, go ahead, step to the left. Officer has your paperwork. Amina Cleaver-Bascom, please, and then Ivan Ortega. All right, ma'am, go ahead, state your name.
Amina Cleaver-Bascom,
And Ms. Cleaver-Bascom, what is your date of birth?
September 12, 2001.
Thank you. All right, ma'am, you are here because you were arrested yesterday on charges of disorderly conduct, fighting a class 1 misdemeanor. I did find probable cause for that. I am setting the hearing on May 27th at 1:30 in the Surprise Municipal Court. Will you go to that?
Yes.
And based on your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. You do need to go to that hearing. If you don't go to that hearing, a warrant may issue for your arrest. You're not to return to the scene of the alleged crime. You're not to have any contact with any alleged victim, complainant, or witness. You may not reside at the same location as any alleged victim or go to the alleged victim's residence, even if you are an owner or renter of the residence. If you currently reside with any alleged victim, you must find an alternative residence. You can arrange for 1 civil standby with law enforcement to collect any essential belongings. You're not to possess any weapons, no drugs without a valid prescription, and no alcohol. You're also going to need to obey the terms of any order of protection or injunction against harassment that has been issued or may be issued. All right, do you have any questions?
No.
All right, go ahead, step to the left, officer, as your paperwork. Ivan Ortega, please, and then Leonard Mucio.
Good morning.
Good morning. All right, sir, go ahead and state your name.
Ivan Serrano Ortega,
And Mr. Ortega, what is your date of birth?
03/10/2003.
All right, sir. I am going to ask you a question
Okay,
based on your striped top.
okay.
I'm seeing you on a Maricopa County direct complaint warrant. I'm also seeing you on a probation violation matter. Are you in custody on anything else?
No.
Okay. All right.
Can I talk real quick?
Yeah.
Yeah, so the case that had happened, they had like dismissed it before, and then, I don't know, I had moved from the house, so I don't know if they sent me a letter for, to go, and I never got it.
Okay. And that can happen, that you can move and the court doesn't know, and then you don't get the information regarding the direct complaint in the mail. Okay, and you told me your birth date was March 10th of 2003?
Yes, ma'am.
All right, sir. All right, you are here because Maricopa County Superior Court issued a warrant for your arrest in a direct complaint matter. That direct complaint alleges that on or about August 5th of 2025, you committed the offense of possession or use of narcotic drugs, a Class 4 felony, and possession or use of drug paraphernalia, a Class 6 felony. In that matter, hold on. In that matter, I am appointing you an attorney, and I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those are in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based on your promise to appear, I'm going to go ahead and release you this morning on your own recognizance. Now, you are also here because you are currently on probation in your case, CR 2024-006306. In that matter, your new charges in the direct complaint would constitute an alleged Term 1 violation of your existing probation matter. In your probation matter, I am appointing you an attorney, and I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. Will you go to those?
Yes.
Okay. And based upon your promise to appear, I'm releasing you in your probation case as well. Now, you are on probation, so you are going to need to contact your probation officer within 72 hours of your release, okay? You're also going to need to make sure you go to your hearings. If you don't go to your hearings, warrants may issue for your arrest.
Yes, ma'am.
All right, go ahead, step to the left. Officer has your paperwork.
Thank you.
Leonard Musio, please, and then Aaron Jones. All right, Mr. Musio, go ahead, state your name.
Leonard Muccio,
Mr. Muccio, what is your date of birth?
5592.
Thank you. All right, sir. You are here because Maricopa County Superior Court issued warrants for your arrest based upon allegations that you violated your probations in your cases CR 2025-101706 and CR 2021-132501. In each of those matters, I am appointing you an attorney, and in each of those matters, I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. Will you go to those?
Yes, ma'am.
All right, then based upon your promise to appear, I'm going to go ahead and release you on your own recognizance in both probation matters.
Okay.
In both probation cases, you will need to go to your hearings, and you're also going to need to contact your probation officer within 72 hours, okay?
Yes, ma'am.
All right, go ahead, step to left.
Thank you.
Officer has your paperwork. Aaron Jones, please. All right, Mr. Jones, go ahead and state your name.
Aaron Jones,
And Mr. Jones, what is your date of birth?
05/05/1984.
Thank you. All right, sir. You are here because you were arrested yesterday on charges of possession of drug paraphernalia, a Class 6 felony, and possession of dangerous drugs, a Class 4 felony. Based on the limited information that I have in front of me this morning, I'm not finding probable cause for those violations. That doesn't mean that those allegations are dismissed, and you must still attend the scheduled court dates in the release order, in which I will tell you, because formal charges may nevertheless be filed. Failure to appear at your court dates could result in a warrant being issued for your arrest, okay? All right, I am appointing you an attorney, and I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. All right, now that's in connection with your new case, or your newer charges. Now, you are also here because a page 2 was filed that alleged a probation violation of your case CR 2023-114773 based upon the new charges for which you were arrested yesterday. So because I found no probable cause for your new charges, I'm also finding no probable cause for your probation violation. Does that make sense?
Yes.
Okay. So However, as with your new charges, I am going to go ahead and in your probation matter, I am appointing you an attorney, and I am setting hearings on April 30th at 8:30 in the downtown Maricopa County Superior Court. However, again, I'm not finding probable cause for that probation violation, but you're still going to need to attend those hearings, okay? All right, because formal charges may nevertheless be filed. All right, and you are on probation, so you will need to contact your probation officer within 72 hours of your release this morning, okay? All right, go ahead, step to the left, officer has your paperwork. All right, James Case.
Good morning, Judge.
Good morning, sir. Are you Mr. Nari?
Nahas. Eddie Nahas.
Okay. All right. And do we have Ms. Stetson on Teams? I think I see her. I'm going to make sure I can hear the Deputy County Attorney, so give me just a second.
No.
Ms. Stetson, can you talk so I can make sure I can hear you?
Yes, Your Honor. Can you hear me all right?
That is perfect. Okay, thank you so much. All right, let's go ahead and get started. I'm going to ask Mr. Case to state his name and his date of birth, and then I'll let you make your appearance, Mr. Nahas.
Perfect. Thank you, Judge.
James Case, 7/30/1999.
Thank you. And on behalf of Mr. Case?
Yes, Eddie Nahas with DM Cantor on behalf of Mr. James Case, and at the end of this hearing, we ask for a public defender to be appointed.
Okay. And Ms. Stetson, would you like to make your appearance on behalf of the state?
Yes, Your Honor. Good morning. Ashley Stetson on behalf of the state.
Thank you. All right. And officer, I'm going to confirm we're clear.
Yes, Your Honor, other than two not cases of it.
Okay. Okay. All right. Thank you very much. All right. Mr. Case, you are here because you were arrested on 2 counts of sexual conduct with a minor. Those are Class 4 felonies. Based upon the information contained in the Form 4, I am inclined to find probable cause for that. But before doing that, I am going to hear argument from the state, and then I'm going to hear argument from your attorney, okay? All right, Ms. Stetson, do you have any argument you'd like to make on probable cause?
No, Your Honor. Based on the Form 4, the state believes that probable cause has been established. Thank you.
Thank you. All right, Mr. Nahas, do you have any argument you'd like to make on probable cause?
In terms of probable cause, Your Honor, we're just, we don't find that there was a finding of probable cause on the basis that Mr. James never confirmed that he actually conducted any acts with the victim in this case. The only thing that he confirmed was that that the email address or the phone number was connected to him. So that's our argument on probable cause.
All right. All right, based on the information in the Form 4, which includes observation by the mother, as well as reports of messages viewed by law enforcement, I am going to go ahead and find probable cause for both counts. I do note the limited notice of appearance, and based upon statements by Mr. Nahas, I am going to go ahead and that the representation is in fact limited to just this morning's hearing. I am going to go ahead and appoint Mr. Case an attorney this morning. I'm also going to go ahead and set hearings on April 30th at 8:30 and May 4th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. I now must consider and decide conditions of release, including bond amount. In order to do that, I have reviewed the information in the Form 4. I have also reviewed a victim statement, which appears to be by the mother. And I have also reviewed the state's written recommendation in this matter. The state's written recommendation is for a $100,000 cash-only appearance bond. All right, I'm now going to have argument if counsel would like to make any. Ms. Stetson, we'll go ahead and start with you.
Thank you, Your Honor. The state is requesting a $100,000 cash-only bond based on the allegations, Your Honor. They are very serious allegations. It is alleged that the suspect, who is 26 years old, had sexual relations with the victim, who does appear to be, based on the Form 4, to be 17 years old, Your Honor. Additionally, the state did read the victim's impact statement, which did provide additional and very significant information. As Your Honor already stated, the victim's impact statement was written by the victim's mother. Your Honor, the victim's mother did mention that the victim does, what was the language she used? Not suffer, but have not neurological, what did she, hold on, she has, where did she say this? That she has an IEP, Your Honor, and has challenges with comprehension. And because of that, Your Honor, the mother does state that the victim has a tendency to be more trusting and may not fulfill intentions or consequences of certain situations, Your Honor. So that's taking that into consideration as well. Additionally, Your Honor, the suspect is a shift manager at the victim at the place of employment. Given that, Your Honor, the place of employment is a place that's commonly employed by teenage kids, and oftentimes their first job. So the state does have concerns about the suspect's position of power in that dynamic. So that is another reason why the state is asking for a bond to be set at such a high bond, as well as the fact that the suspect is looking at mandatory imprisonment. So, in addition to that, Your Honor, the state is asking for the statutory mandated monitoring, which will be electronic monitoring in this case, as well as no contact with the victim, and all other conditions outlined in the state's written recommendation. Thank you, Your Honor.
Thank you, Ms. Stetson. Mr. Nauhaus.
Yeah, of course, Your Honor. Thank you. So in terms of the victim's statement that was provided, again, that was written by the mother. That wasn't actually written by the victim herself. And I just want to point that out to the court. Our ask in this case is for Mr. Case to be released to pretrial services. If the court believes additional supervision is warranted, then we ask for pretrial services with electronic monitoring. In the alternative, we're asking for a nominal bond to be set, a secured bond amount, $100,000 cash only. Again, we understand the crimes that were alleged against Mr. Case, but we think $100,000 cash only bond is essentially, it's not in the interest of public safety. Mr. Case is 26 years old. He's born and raised in Arizona. His family, his school, his support system are all based here. He has no criminal history whatsoever. He's currently a student at Brookline College studying occupational therapy. He's going to be going into his second year. He's almost graduated. It's a hybrid program. He actually had class today that he was going to attend. His semester is almost done. And he's not a flight risk to this court. He will appear at every single court hearing. He currently lives with his mom and daughter. He has a 4-year-old daughter who he has full custody of right now. He helps his mom with rent. He fully supports his daughter and takes her to school. He takes care of her basic needs. And so he does have ties to the community. He's not a flight risk. He has no criminal history whatsoever. And also, Mr. Case he does not pose a threat to the community. He's a strong family support. He has 2 sisters and a brother that he's very close with.
and any concern can be addressed through release conditions. And Your Honor, if I can also address the release conditions in this case, if he's found to have either on pretrial services or with a bond amount that is essentially nominal, we're asking for Mr. James to have contact with his 4-year-old daughter. He assumes full custody of her. Her biological mother is not in the picture, so he takes care of her daily needs. She's about to finish kindergarten. He's enrolling her into, I believe, preschool. She was in preschool. He's going to enroll her in kindergarten soon. His daughter is not involved in this case whatsoever. She wasn't harmed by this case. And essentially she has no part in this case. So again, he's proven to the court that he has no criminal history whatsoever. He's not a risk to the community. He's not a flight risk to the court. So we're asking for either pretrial services, either with electronic monitoring, or for the court to impose a secure nominal bond in this case. And again, we're asking for him to remain in contact with his daughter in this case. And also, I want to address another point. The state highlights that implies that he might be in a position of trust based on the statute. Mr. Case is not in a position of trust. He was a shift leader at the establishment where allegedly the Form 4 highlights. Again, it would have to be the owner of the establishment for him to be established in a position of trust. And I do believe that for the charges, he is probation eligible at the end of the day. So based on that, we're asking for pretrial services or with electronic monitoring, or for the court to enforce a nominal bond, along with him having contact with his daughter, since the dependency of the case will stretch out for a long period of time and he wants to be involved in her life. So those are asks. Thank you, Judge.
All right. Counsel, thank you very much for your argument. Having considered the Form 4, the victim statement by the mother, as well as state's written recommendation argument by counsel, I'm going to go ahead and set a secured appearance bond in the amount of $150,000. In the event that Mr. Case is able to post that bond and secure his release, he would be subject to certain pretrial release conditions. Those include electronic monitoring, house arrest. He's not to have any contact with any alleged victim, complainant, or witness. He's not to consume any drugs without a valid prescription. In reference to Mr. Case's argument raised by counsel with regard to Mr. Case's own minor child, in these cases, it is typical for me to order no minor contact. However, in view of the fact that this is his biological child, I am making this provision. You may not be alone with nor have the care or physical custody of anyone under the age of 18, even temporarily, without further order of the court. Okay?
So just to clarify, he's not allowed to essentially see his daughter?
He's allowed to have supervised contact.
Okay.
As long as
because he's currently living with his mother. I just want to make sure if that's okay, if he can still reside at the house.
Yes, but he may continue to reside in the house, but he may have supervised contact only with the child.
Okay.
And I will make that explicit. Hold on.
So, Judge, if I can get clarification on that, so he can reside at the house, he can be with his daughter as long as his mother is present?
Right. because you had questions and because I was seeking to clarify.
Thank you, Judge.
Defendant may continue to reside in the residence as long as any contact with his minor child is directly supervised by his mother or other responsible adult.
Okay.
Is that clear?
Yeah, so they can all be at the house, but anytime, they just can't be alone in the house, correct?
Right, that's direct supervision. To me, that is line of sight supervision.
Okay.
Okay? All right, Ms. Stetson, do you want to chime in at all on that, since I had some discussion with Mr. Nahas?
No, Your Honor. I think that's sufficient.
That's sufficient? Okay.
And Judge, sorry, one more thing. It's a $150,000 secured bond?
Secured.
With electronic monitoring if he posts?
Yes, with electronic monitoring, which is required for this type of crime, right? Okay. All right. So with that, anything further from you, Ms. Stetson?
Nothing further, Your Honor.
Anything further from you, sir?
Yes, can I just get the dates again for the court appearance?
You absolutely can. We will also give you a courtesy copy of the order.
Okay, yeah, that works as well. Thank you.
Okay.
Am I allowed to speak to Mr. Case just really quickly?
Of course.
Thank you.
All right, Ms. Stetson, I appreciate your appearance, and you are, as always, welcome to stay, but I understand if you would like to disconnect.
Thank you, Your Honor. The state will be disconnecting now.
Thank you. All right, Darren Evans, please. All right, yep, right up to the podium. All right, Mr. Evans, go ahead, state your name.
Darren Michael Evans.
And Mr. Evans, what is your date of birth?
04/24/1988.
Thank you. All right, sir, you are here because you were arrested on charges of failing to register as a sex offender, a Class 4 felony. I did find probable cause for that. I am appointing you an attorney. I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. Will you go to those?
Yes, Your Honor.
All right, then based upon your promise to appear, I'm going to go ahead and release you this morning to pretrial services. Pretrial services will do things like remind you of your upcoming hearing dates, okay? You do need to go to those hearings on the 8th and the 12th, because if you don't, a warrant may issue for your arrest, all right?
Yes, Your Honor.
All right, go ahead, step to left, officer has your paperwork. All right, we do have 3 house calls this morning. Our first house call is Joshua Lorenzo. Joshua Lozano. Mr. Lozano, date of birth is April 20th of 1992. Mr. Lozano is not able to be with us because he is not following orders. All right, Mr. Lozano is here because he was arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony, possession of drug paraphernalia, a Class 6 felony, shoplifting, a Class 1 misdemeanor, and possession of narcotic drugs, a Class 4 felony. I did find probable cause for all of those. Because Mr. Lozano was on release in his case, CR 2026-109801, on the date of offense for his new felony charge, I am holding him non-bondable in his new felony matter. All right, now Mr. Lozano is also here because the Peoria Municipal Court issued a warrant for his arrest. This warrant is based upon charges that Mr. Lozano committed the offense of shoplifting, a misdemeanor. In that matter, I am indicating that an attorney should be appointed for Mr. Lozano at his next hearing, which will be in the Peoria Municipal Court on April 28th at 9 a.m. And the purposes, attorneys should be appointed for limited representation regarding the bond issue only because I am setting a $50 secured appearance bond in that matter. All right, our next house call is Cedric Shoup. Mr. Shoup's date of birth is April 15th of 1995. Mr. Shoup is unable to be with us this morning because he is combative. Mr. Shoup is here because the University Lakes Justice Court issued a warrant for his arrest. This is a post-adjudication failure to pay or comply with court orders warrant dated March 25th of 26. Based upon underlying charges of a June 2019 criminal damage violation. In that matter, I am appointing him an attorney for limited representation regarding the bond issue, only because I am setting a $50 secured appearance bond in his matter. I am also setting a hearing on April 29th at 8:30 in the University Lakes Justice Court. All right, our last house call is Christopher Alvarado. Mr. Alvarado is unable to be with us this morning because Mr. Alvarado is currently combative. Mr. Alvarado's date of birth is June 10th of 1996. Mr. Alvarado is here because the Maricopa County Superior Court issued a warrant for his arrest in a direct complaint matter. That direct complaint alleges that Mr. Alvarado committed the offenses of possession or use of dangerous drugs, a Class 4 felony, and possession or use of drug paraphernalia, a Class 6 felony. In that matter, I am appointing him an attorney, and I am setting hearings on May 8th at 8:30 and May 12th at 8:30. Both of those will be in the downtown Maricopa County Superior Court. If anything changes after I talk to the house calls in-house, I will update my written orders in those matters. All right, and that does bring us to the end of our 5 a.m. initial appearance calendar, and we are going to go ahead and stand adjourned until 8 a.m., and we are off the record.
Thank you. You may be seated. Can the Spanish interpreter hear the court?
Yes, this interpreter can hear you. Can the court hear the interpreter?
I can. We will go ahead and get started. Thank you for being here. Good morning. This is the time set for the 8 a.m. initial appearance calendar on April 24th.
Muy buenos días. Esta es la comparecencia inicial de las 8 de la mañana del 24 de abril.
The court's orders for the taking of DNA and fingerprints
La orden judicial para la toma de huellas dactilares
that were given on the first calendar of this month
de huellas dactilares y de muestra de ADN que se dio en el primer calendario de este mes
shall apply to all matters on this calendar.
aplicará a todas las causas del calendario de esta mañana.
I will call you each one at a time to the podium.
Voy a llamarlos uno a la vez para que pasen al podio.
I'll provide a second name to sit in the chair outside of this room.
Y proporcionaré el segundo nombre de una persona y le pediría a esa persona que se siente en la silla que está fuera de esta sala.
I will let you know what you are here for.
Les explicaré por qué es que están aquí.
If I have appointed an attorney.
Si es que les asigné un abogado.
If you have a bond.
Si es que se fijó una fianza en su caso.
And what your release conditions are.
Y les indicaré cuáles son sus medidas cautelares.
And Madam Interpreter, I'm going to read the victim's rights advisement next. Do you have a copy of that?
Yes, the interpreter has a copy, Your Honor.
Are you okay with me reading it incomplete in English and then allow you to translate it completely?
Certainly, Your Honor. Thank you so much for asking.
Thank you, Madam. Okay, so I'm going to do the victim's rights advisement. If you are the victim of a crime with a case pending before this court, you are advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office.
Si usted es la víctima de un delito en una causa pendiente ante este tribunal, se le informa que usted goza de determinados derechos según la ley de Arizona, incluyendo, entre otros, el derecho al trato justo, respetuoso y con dignidad, el derecho a un proceso sin dilación, el derecho de asistir a las diligencias judiciales ventiladas ante el tribunal, el derecho de permitir o no que el acusado o su abogado defensor lo entreviste, el derecho de expresar su opinión ante el juez cuando decida cuestiones de excarcelación, la negociación de un convenio resolutorio, la programación de diligencias judiciales y la imposición de la pena, y el derecho a la indemnización por parte del responsable de los daños. Si no ha recibido por escrito los derechos de la víctima u ofendido, comuníquese con el Departamento de Servicios para Ofendidos de la Fiscalía.
And does Jose have the headphones? Yes. All right. Can I have Mr. Jose Rivera Jimenez to the podium?
José, ¿tiene usted los audífonos? Señor José Rivera Jiménez, por favor, pase al podio.
And Mr. Gustavo Valenzuela to the chair.
Señor Gustavo Valenzuela, pase usted a la silla.
Good morning, sir. May I please get your name and date of birth?
Buenos días, señor. Por favor, deme su nombre y su fecha de nacimiento.
José Alejandro Rivera Jiménez, 28 del 0899.
José Alejandro Rivera Jiménez, 0828-1999.
Thank you. And Madam Interpreter, he does have the headphones. Are you able to do this simultaneously at this point?
Yes, Your Honor.
Thank you. Sir, we are here today on a new case. It is for one count of armed robbery with a deadly weapon, a Class 2 felony. One count of kidnapping, a Class 2 felony. Probable cause has been found, and I am appointing an attorney to represent you. You are going to have a status conference, April 30th at 8:30, and a preliminary hearing, May 4th at 8:30. In this case, you do have a secured appearance bond in the amount of $100,000. In the event you postpone, you will be released to the supervision of pretrial services, and you will be equipped with electronic monitoring. You also have written conditions of release. You may not return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You may not have contact with any co-defendants, and you may not possess any weapons. This will all be in your paperwork, sir. Did you have any questions?
No.
All right, if you will take a step to your left, the officer will get you that paperwork. If I could have Mr. Gustavo Valenzuela to the podium,
Señor Gustavo Valenzuela, pase al podio.
and Richard McLennan to the, or did he just become a house call?
Yeah, so that's what they did when it came, the number one, the house call.
Okay. Can I have Richard Hernandez to the chair? May I get your name and date of birth?
Gustavo Valenzuela Mercado, 23 de noviembre del 2000.
Gustavo Valenzuela Mercado, November 23rd, 2000.
Thank you, sir. You are here today on a new case. It is for one count of unlawful flight from a law enforcement vehicle, a Class 5 felony. One count of resisting arrest, Class 6 felony. One count of driving with a license that was suspended, revoked, or canceled, a Class 1 misdemeanor. And one count of criminal trespass, a Class 2 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent you. You are going to have a status conference, May 8th at 8:30, and a preliminary hearing, May 12th at 8:30. Those will both take place in the downtown Superior Courthouse. I do note that it looks like you also have a warrant from the City of Phoenix, so it does look like you will likely see another judge today at either 10 a.m. or 4 p.m. to address the pending warrant from the City of Phoenix. When I reviewed your case, I did review the allegations in this case. I also took a look at your criminal history. It does look like the only thing you have is that warrant out of the City of Phoenix related to a DUI. So after reviewing that, I have decided I am going to release you today on your own recognizance. That is your promise to appear at these hearings. This is related only to this case. You still will have to address the warrant with the City of Phoenix judge. However, I am cautioning you that you must appear at these hearings. If you fail to appear at these hearings, a warrant will issue for your arrest, and then you will be held on bond at your next hearing. So you must make sure that you comply with all your release conditions. Some of those do include not driving a motor vehicle without a valid driver's license, not possessing or consuming drugs without a valid prescription. This will all be in your paperwork, sir. Did you have any questions?
No, está bien.
No, that's fine.
If you will take a step to your left, the officer will get you your paperwork. And Madam Interpreter, do you mind asking the gallery to raise their hand if anybody else will need your assistance?
Happy to do so, Your Honor. ¿Hay alguien más que se encuentre presente que necesite la ayuda de un intérprete en español? Levante la mano.
All right, nobody has raised their hand. Thank you so much for helping us this morning. Feel free to disconnect.
You're welcome, Your Honor. Have a good day.
You too. If we could have Richard Hernandez to the podium and Michael Alday to the chair. May I get your name and date of birth?
Richard Hernandez, 5/11/81.
Thank you, sir. It does look like you are here today on two cases. You were here on a direct complaint that was filed, and you're also here on a failure to appear bench warrant that was issued for you. So we'll go over each of these cases. A direct complaint warrant was filed, or a direct complaint was filed on April 6th of 2026. It is for an offense date of October 29th of 2025 for one count of unlawful flight from a law enforcement vehicle. And then, as I mentioned, you're here on a second case. That one is actually from 2023. You failed to appear at a hearing, and a warrant issued March 30th, 2023. That has an underlying charge of one count of dangerous drug possession and one count of drug paraphernalia. I'm going to appoint an attorney on your new case, and I'll affirm the attorney previously appointed to represent you on your pending case and give you some hearing dates. You're going to have a status conference April 30th at 8:30, an evidentiary hearing May 1st at 1:30, and then your last hearing is going to be May 4th at 8:30, and that's going to apply to both the direct complaint as well as the failure to appear case. So you have 3 hearings coming up between both cases that all take place in the downtown Superior Courthouse. On the case where you failed to appear in 2023, you had a secured appearance bond in the amount of $1,000. However, on your new case, the new direct complaint that was filed, because you were out on felony release at the time of this alleged offense, you're not eligible for bond today on your new case. So posting that $1,000 bond would not get you released until you have that evidentiary hearing on May 1st at 1:30. That is the time set to determine if bond will be set on the new charges for unlawful flight from a law enforcement vehicle. This will be in your paperwork, sir. Did you have any questions?
How is that? They're charging me on something that they never, like, that makes no sense.
I'm not sure if I understand your question.
I mean, you're charging me on a crime that I never even got picked up for or nothing and stuff. How is that?
So although you may not have been arrested for it prior to
So
now.
they're just assuming it was me, that they're saying that it was there? How's that? That makes no sense.
So you're going to have an opportunity to defend yourself against this case. You're not being found guilty of it at this time. The state has brought
But you're
these
charging me
charges
of it
against you.
you're charging me of it for no reason right now. You don't know who it was or anything, but you're just putting it on me now? How is that?
So the state has provided, or they have indicated that they have enough information to move forward with this charge against you, so they filed this case, and as a result, the warrant issued for your arrest. However, because you failed to appear at that other hearing in 2023, that means you were still out on felony release at the time of this new alleged offense, which makes you not eligible for bond. So I've appointed an attorney to
But they're
represent
assuming
you.
that was me, that it wasn't me.
Again, at this point, they're just allegations and a petition that has been
Exactly,
filed
so they're
against you.
allegations, but you're holding me on allegations that are just could be made up.
So that's what the law requires. If you're out on felony release and you're charged with any new felony cases, the law requires me to hold you non-bondable. It's not within my discretion today to let you out because you were out on felony release. That is just what the law requires. It's not something that I am choosing to do based on the information. It's what the law requires if you're charged with an additional felony while you have a felony case pending. So you will have a chance to defend this case. You have not been found guilty of these charges, but
I
you
haven't
will
been
have
charged
to,
with it either.
Well, you have been charged. The prosecutor has filed the charges against you. So this is a case that has been charged.
So how come I didn't receive something in the mail or anything else besides that until now?
So they don't always mail information. Oftentimes they will file the direct complaint and issue a warrant for their arrest, and that's what happened in your case. Nothing went to your location. They may not have had an address available for you, and as a result of that, the warrant issued for your arrest. This is a fairly recent one. As I mentioned, it is from April of this year, so it just recently issued. But you will have to address this at your hearing on April 30th at 8:30. That's the time set where you'll meet with your attorney as it relates to your new charges. And then May 1st is when you will have a hearing with your attorney and the judge to determine if bond will be set on these new charges. If you'll take a step to your left, the officer will get you that paperwork. Michael Alday to the podium. Wong Ching Yiming to the chair. On number 22. Thank you. Will it be the same date and time as the previous one? Thank you. May I get your name and date of birth?
Michael Alday, September 16, 1997.
Thank you, sir. You are here today on a new case. It is for one count of dangerous drug possession, a Class 4 felony, one count of disobeying an order of the court, a Class 1 misdemeanor, and one count of assault, a Class 2 misdemeanor. Probable cause has been found, and I am appointing an attorney to represent you in this case. You're going to have 3 hearings coming up. You are going to have a status conference April 30th at 8:30, an evidentiary hearing May 1st at 1:30, and a preliminary hearing, May 4th at 8:30. At the time of this alleged offense, you were out on felony release for a different case that you currently have pending, and because of that, you're not eligible for bond today. The time set to determine if bond will be set on these charges is the evidentiary hearing on May 1st at 1:30.
The evidentiary hearing, what is that? They're gonna say what evidence they got against me?
So that's the time to present information to determine what your bond, if a bond should be set on this case.
Oh, it's only for that court?
Yes, on May 1st. So it's just to determine if bond should be set. And so you'll
What
meet.
determines that? My bad, I'm not trying to fight against it, it's whatever, but like what determines that?
So they're going to take a look at multiple things. They're going to take a look at the allegations in this case. They're also going to take a look at any criminal history you may have. They're going to take a look at any prior failures to appear that you may have. And based on all of that information, they'll determine whether or not you're eligible for bond. If you are eligible, what should that look like? Should you have a bond? Should you be released to pretrial services? Or should you be released on your own recognizance?
Yeah, I got and then look, so, the evidentiary hearing, could it be because they don't have any, like, because it's just, he say, she say? Because that's, in my case, like, that's what it is.
Well, the evidentiary hearings that I'm referring to relates to whether or not bond should be set, not whether or not you're guilty of the crimes that they're alleging you committed. That's going to be, start with your status conference on April 30th at 2026. You're going to talk to your attorney at that time. If you have any information as it relates to whether or not how you're going to defend and move forward with this case, provide your attorney that information on April 30th. They may work out some sort of plea deal. They may go to trial, but provide that information as it relates to whether or not you're guilty of the crimes that you're being allegedly have committed. The evidentiary hearing on May 1st is only related to whether or not you should be given a bond while these charges are pending before the court. So you have to stay in custody until at least May 1st. May 1st is when they'll determine whether or not you'll be given a bond in order to be released while you defend yourself against these charges.
Where I'll be given a bond or get released?
That's what they'll decide on May 1st. That judge will decide that. I don't know what they will do. They're going to take a look at those things. They're going to take a look at your criminal history. It doesn't look like you have a large criminal history or any failures
But they found probable cause?
I'm sorry?
They found probable cause?
I'm finding probable cause today based on the information that I have here today. That just simply says the information they have provided, I have enough to believe that you may have done these crimes. But again, it's not finding you guilty of these crimes. You can defend yourself against them. But I have enough information today for purposes of probable cause, okay? Did you have any further questions?
What are those purposes?
So again, it does indicate that you had a dangerous drug, which I believe, I'd have to review the notes again. I believe there was either a test or an admission. Oh yes, they tested the substance that was located on you, and it tested positive for methamphetamine. And so that's the basis for finding probable cause for the dangerous drug charge. That's your only pending felony charge, and that's the reason you're being held non-vulnerable.
And then the restraining order?
The other one indicates that there's information that there were witnesses as well as the protected party who indicated that they did have contact with you when there was an active order of protection. So that's the information to believe that you violated that order of protection. It does indicate that there may have been consent by the alleged victim or the protected party, but that in and of itself does not make it not a violation of the order of protection. So if there's an active order of protection, even if the protected party indicates to you that they want to have contact, you agreeing to that contact is still a violation. So again, the information indicates that there was an agreement between you and the protected party to have contact, but again, that's a violation of the order of protection.
So they're saying I was there at the house?
Correct. Yes, there's information, there's a witness also indicating that you were at the location that they alleged.
Was it an outside witness, like not someone from outside the house?
I do believe it's from people in the home.
Oh, yeah, we good, yeah.
And then lastly,
it's okay.
There was an indication that an assault took place, I believe.
Was there an arrest, and then was there evidence picked up?
I'm not sure what you mean by that.
Like, was there an arrest at those crimes? And then the evidence that I was inside the house? You get what I'm saying?
I don't think the allegations allege that you were necessarily inside the homes. It's just that you were at a location where the protected party was, which is a violation of your probation. And then there was an allegation that there was an active bleed on the alleged victim that allegedly resulted of a physical altercation the two of you may have. So that's the information here today, which is why I'm finding probable cause. It's the probable cause on the dangerous drug possession that's getting you held non-bondable because you were out on a separate felony case.
Because the restraining order, you guys don't got that much evidence.
That's the misdemeanor charge, but your dangerous drug possession is a felony charge, and that's why you're being held non-bondable is because of that charge.
Okay, cool.
Okay.
Yeah.
Are you reprinting that? Okay, perfect. If you'll take a seat in the gallery, we're reprinting that to include all of your hearing dates. They'll bring that out to you.
Okay.
Wong Cheng to the podium. Sean Lyons to the chair. Can I get your name and date of birth?
Wong Cheng, Yiming, 1998, May 12th.
Thank you, sir. You are here today on a new case. It is for one count of aggravated assault with a deadly weapon or dangerous instrument, a Class 3 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference April 30th at 8:30, and a preliminary hearing May 4th at 8:30. In this case, you do have a secured appearance bond in the amount of $75,000. In the event you post that bond and are released from custody, you do have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess any weapons. This will all be in your paperwork, sir. Did you have any questions?
No, ma'am.
If you'll step to your left, the officer will get you that paperwork. Thank you, sir.
All right, thank you.
Sean Lyons to the podium. Angela Guerrero to the chair. Can I get your name and date of birth?
Sean Lyons, 6686.
Thank you, sir. It does look like you are here today on two cases. You're here on a new case, and you're also here on a warrant from the Peoria Municipal Court. Your new charges are for one count of aggravated assault, a Class 3 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference April 30th at 8:30, and a preliminary hearing May 4th at 8:30. In this case, you do have a secured appearance bond in the amount of $10,000. You have a second case on the calendar. It's a warrant from the Peoria Municipal Court. It's a post-adjudication warrant related to a criminal damage charge from 2024. What that typically means is you probably failed to pay some fines or complete a class. Since you're currently going to be in custody on those new charges, I'm going to appoint an attorney, set a hearing in an arraignment hearing in the Peoria Municipal Court, April 28th at 9 a.m. I'm putting what's called a $50 placeholder bond. What that does, it ensures that you get credit for any time served, and you're also taken to any of your hearings. However, if you post the bond on that other case, just simply post the $50 on this case. You'll be released on both. You need to ensure you attend all of your hearings. You have release conditions as well. You may not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness, and you may not possess weapons. This will be in your paperwork, sir. Did you have questions? Please take a step to your left. The officer will get that for you. Angela Guerrero to the podium. Allison Boshana to the chair. May I get your name and date of birth?
Angela Guerrero, 82689.
Thank you, ma'am. It does look like you are here today on two cases. You're here on a new case. You're also here on a warrant from the Goodyear Municipal Court. Your new charge is for one count of shoplifting, removal of goods, and one count of shoplifting, concealment, both Class 1 misdemeanors. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have an arraignment hearing in the El Mirage Municipal Court, May 4th at 10 a.m. Your Goodyear Municipal Court warrant was for failing to appear at a hearing relating to one count of shoplifting, removal of goods, and one count of concealment, both Class 1 misdemeanors. In that case, I'm going to appoint an attorney, and you'll have an arraignment hearing in the Goodyear Municipal Court, April 29th at 8:30. So you do have two hearings coming up, two different locations. It will be in your paperwork. You have a secured appearance bond of $500 on each case for a total bond in the amount of $1,000. In the event you post bond and are released from custody, you do have written conditions. You may not return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness. You'll also need to ensure that you attend your hearings. If you fail to appear at either one, a warrant will issue, and then you'd also forfeit that bond you posted. This will be in your paperwork, ma'am. Did you have any questions?
No.
Please take a step to your left, and the officer will get that for you. Allison Oshana to the podium, and Ashley Wright to the chair.
Hello.
May I get your name and date of birth?
Allison Maria Shanna, 6/24/1995.
Thank you, ma'am. You are here today on three cases. You are here today on a new case and two probation violation warrants that were issued. Your new charge is for 1 count of criminal damage, a Class 6 felony. Your probation violation warrants allege you violated terms 3 of your probation. I'm finding probable cause on your new charges. I'm appointing an attorney to represent you in all 3 cases. You have 2 hearings coming up. You're going to have a status conference along with a probation revocation hearing, April 30th at 8:30, a preliminary hearing, May 4th at 8:30. On your new case, you have a secured appearance bond of $500. In each probation case, it's $250 each. That is a total bond of $1,000 for all 3 cases. In the event you post bond and are released from custody, you do have written conditions of release. You're not to return to the scene of the alleged crime. No contact with any alleged victim, complainant, or witness. You must contact your probation officer within 72 hours. You're also going to need to ensure that you attend all of your future hearings. If you fail to appear at any of them, a warrant will issue for your arrest and you'd forfeit the bond you posted. This will be in your paperwork, ma'am. Did you have any questions?
No, that sounds good. Thank you.
Thank you, ma'am. If you'll step to your left, the officer will get that for you.
Okay, thanks.
Ashley Wright to the podium. Esmeralda Patino to the chair. May I get your name and date of birth?
Ashley Wright, July 3rd, 91.
You're here today on 3 cases. There are 3 probation violation warrants with allegations you violated terms 3 and 5. I'm appointing an attorney and setting a probation revocation hearing, April 30th at 8:30. You have a secured appearance bond of $350 in one case, $250 in the second, $150 in the third. That's a total bond of $750 between the 3 cases. In the event you post that bond and are released from custody, you do have written conditions. You may not possess weapons or alcohol, and you must contact your probation officer within 72 hours. This will be in your paperwork, ma'am. Did you have any questions?
Nope.
Please take a step to your left, and the officer will get that for you. Esmeralda Patino to the podium, and Pedro Rodriguez to the chair.
Good morning.
May I get your name and date of birth?
Esmeralda Patino, November 27th, 1978.
Thank you, ma'am. You are here today on a probation violation warrant with allegations you violated terms 3 and 5 of your probation. I'm appointing an attorney and setting a probation revocation hearing, April 30th at 8:30. You have a secured appearance bond in the amount of $500. In the event you post bond and are released from custody, you do have written conditions of release. You are not to possess any weapons or alcohol. You must contact your probation officer within 72 hours of release. You'll also need to ensure that you attend all of your future hearings. If you fail to appear at any of them, a warrant will issue and then you will forfeit the bond that you posted. This will be in your paperwork, ma'am. Did you have any questions?
I just had, I had something to say, I guess. The last few days, I spent over $2,000 trying to get everything right. I got my driver's license back, got insurance, got an SR-22. I pretty much expelled all the money I have. And yesterday, I even did this. So I was just, I guess I was trying to let you know, I'm trying to do this, everything the right way. So I'm like, I've used over $2,000 in the last week, borrowed and everything. DMV, we also with the Department of Public Safety, everything. Insurance, I got an SR-22. So I guess, I don't know, just trying to let you know, I was on my way trying to do that. And that's why I was so exhausted and tired, and that's why I ended up getting pulled over. But yeah.
So you're not here related to being necessarily pulled over. You're here because the allegations include that you haven't been in contact with your probation officer.
Yeah.
It looks like you were previously in custody and you were released on February 9th. And the allegations indicate that once you were released, you had 72 hours to contact your probation officer, and you failed to do so. It does look like they've been attempting to contact you. Looks like they've contacted family members, and at this point, everyone has indicated that they have been unable to locate you as well. And that's the reason this warrant was issued, is because you weren't complying with your probation officer.
So the bond's at $500, you said?
So the bond is $500. If you post that and get released, just make sure you contact your probation officer.
That's why I was saying
hours.
that I've already used so much this week trying to get everything right. And this was my next other step, and, you know, it's just like...
So what I'm hearing is you're working on getting things together, but that didn't include contacting your probation officer, which, again, you haven't been in contact with multiple months, which is the reason you were here. So that bond will need to be posted in order to be released. But again, make sure you do contact your probation officer to avoid having this happen again, okay?
Okay.
All right, please step to your left. The officer will get that paperwork for you. Pedro Rodriguez to the podium. Bernardo Bravo to the chair. I'm going to have you reprint this next one, number 5. Can I get your name and date of birth?
Pedro Rodriguez, 81473.
Thank you, sir. It does look like you are here today on a new case for 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of dangerous drug possession for sale, a Class 2 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference May 8th at 8:30 and a preliminary hearing May 12th at 8:30. I'm going to release you to the supervision of pretrial services, but you have written conditions. You are not to possess any weapons. You are not to possess or consume any drugs without a valid prescription. Along with your paperwork, you're going to get an envelope. You'll need to read the instructions and contact pretrial services within 72 hours of your release. You'll need to ensure that you attend all of your hearings. If you fail to appear at any of these hearings, a warrant will issue and then you will be held on bond at your future hearing. Did you have any questions, sir?
No, ma'am.
All right, we did need to reprint your paperwork. If you could take a seat in the gallery, we'll bring that out to you, okay?
Thank you very much.
Mr. Bravo to the podium. Frank Filani to the chair. Can I get your name and date of birth?
Bernardo Bravo, Jr., 6/24/1996.
Thank you, sir. You are here today on a new case. This is for 1 count of criminal trespass of the first degree, 1 count of aggravated assault of a first responder, a Class 5 felony, 1 count of resisting arrest, a Class 6 felony, 1 count of criminal damage, a misdemeanor, and 3 counts of disorderly conduct, a Class 1 misdemeanor. For purposes of today's hearing only, I'm not finding probable cause for the criminal trespass. I'm not finding probable cause for the criminal damage. It doesn't mean they're dismissed. I just simply don't have enough information today in order to find probable cause, but it doesn't mean they won't supplement their reports and charge you with it. I'm going to find probable cause on the other cases or the other counts, appoint an attorney to represent you. You're going to have a status conference May 8th at 8:30, preliminary hearing May 12th at 8:30. I am going to release you today to the supervision of pretrial services, but you are going to have written conditions. You're not to return to the scene of the alleged crime, no contact with any alleged victim, complainant, or witness. You may not possess any weapons. You're going to get an envelope with your paperwork. You need to read the instructions and make sure you contact pretrial services within 72 hours of your release. And then you'll also need to ensure that you attend your hearings. If you fail to appear at any of them, a warrant will issue and then you'll be held on bond at your next hearing. Did you have any questions, sir?
So the ones that you found probable cause for were assault and what?
Disorderly conduct, resisting arrest, and the assault on the first responder.
All right.
Anything further, sir? Okay, so step to your left, the officer will get you that paperwork. Frank to the podium, and Allison Wolf Jimenez to the chair, please.
Good morning.
Good morning. May I get your name and date of birth?
Frank Fliani, 040267.
Thank you, sir. You are here today on a new case. It is for 1 count of narcotic drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, 1 count of criminal trespass, a Class 3 misdemeanor.
No.
Hold on, sir. I'll give you an opportunity to ask questions at the end, okay? For purposes of today, I'm only finding probable cause for the criminal trespass charge. I'm not finding probable cause for the narcotic drugs or the drug paraphernalia.
I don't have any of those charges.
So they have included those as charges. However, I don't have enough information to find probable cause to date for those charges. That doesn't mean that the charges are dismissed. They may end up charging you with those, but they would have to supplement their report or test any substances they may have located. But for purposes of today, I don't have enough information for anything except the criminal trespass. I am going to appoint an attorney to represent you, and you're going to have a status conference May 8th at 8:30 and a preliminary hearing May 12th at 8:30. I'm going to release you to the supervision of pretrial services. You have to contact them within 72 hours of your release. You also have written conditions. You may not return to the scene of the alleged crime. No contact with any alleged victim, complainant, or witness. I do note it looks like you have multiple other warrants from other cities. So while I may be releasing you today on this case, you may be held and other cities may come pick you up as it relates to your other warrants. All of this will be in your paperwork. Did you have any questions?
Yeah, I don't have any warrants.
You'll have to talk to the officers. I have a note in here that you have a hold out of the city of Mesa and you have a hold out of the city of Scottsdale. And it looks like you might have a misdemeanor probation violation in Phoenix. That's just what the notes indicate. Talk to the officers when they take you to the back. I'm releasing you as it relates to your new charges, but again, you may be held on some of these other cases, okay? All right, take a step to your left. The officer will get you that. Allison Jimenez Wolf to the podium. Alfred Barnes to the chair. May I get your name and date of birth?
Alicia Wolf Jimenez, 12505.
Thank you, ma'am. You are here today on two cases. You're here on a new case as well as your probation case. Your new charge is for 1 count of drug paraphernalia possession, and I need to change that. That should actually be a Class 6 felony, and 1 count of criminal trespass, a Class 3 misdemeanor. Let me update that to reflect the correct felony offense. Okay. I am finding probable cause and appointing an attorney to represent you. You are going to have a status conference May 8th at 8:30 and May 12th at 8:30. For your probation case, you're here because you were on probation and they're alleging a Term 1 violation based on the new offense they've alleged that you've committed. I'm going to appoint an attorney and set a probation revocation hearing April 30th at 8:30. So you have 3 hearings coming up. I am going to release you today to the supervision of the Adult Probation Department. You do have written conditions. You're not to possess or consume drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. And you must contact your probation officer within 72 hours of release. This will be in your paperwork, ma'am. Did you have any questions? Okay. We do need to reprint number 19. If you could please take a seat in the gallery, we'll bring that out to you. Alfred Barnes to the podium. Quintana Parquette to the chair. Mr. Barnes, he has long hair and a gray t-shirt. Can I get your name and date of birth?
Alfred Barnes.
And your date of birth, sir?
9/9/1973.
Thank you, sir. You are here today on a new case. It's for 1 count of dangerous drug possession, a Class 4 felony, 1 count of misconduct involving weapons, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference May 8th at 8:30 and a preliminary hearing May 12th at 8:30. I'm releasing you today to the supervision of pretrial services. You do have written conditions. You may not possess weapons. You may not possess or consume drugs without a valid prescription. You'll get an envelope with your paperwork. You'll need to read the instructions, contact pretrial services within 72 hours of release, and then make sure you attend all of your hearings. If you fail to appear, a warrant will issue, and then you'll be held on bond at your next hearing. Did you have any questions?
No, ma'am.
If you'll take a step to your left, the officer will hand you that paperwork.
All right, thank you.
Thank you, sir. Ms. Parquette to the podium. And I apologize in advance for mispronouncing this name, but Oghale Emosia, Emeosa to the chair, please. And may I get your name and date of birth?
Quintana Parquette, 12/20/94.
Thank you, ma'am. You're here today on a warrant. It's an out-of-county warrant from the Puerto Justice Court.
Yeah.
Looks like you failed to appear in 2023 for a disorderly conduct, 2 counts of disorderly conduct from 2022. Due to the nature of your charge, you're not entitled to court-appointed counsel, but you can hire one at your own expense if you would like. You're going to have a hearing in the Puerto Justice Court on April 29th at 8:30.
Okay.
If I were to release you today on your own recognizance, could you get yourself to that hearing?
Yes.
And do you promise to appear at that hearing?
Yes, ma'am.
Okay. I'm going to release you. You'll have a short time to get there. I'm not familiar with the area, so I'm not sure how far Sanders, Arizona
Yeah,
is.
it's about a 5-hour drive from here. And that's the thing is that, I actually went to court for it, and they closed the case. And then I just found out, yesterday when I was interacting with the police officer that they had a warrant for my arrest. And I was like, oh, okay, because Judge Yellowhorse had closed out that case. So I didn't know what had happened, but I can make it there on the 29th.
Okay. It does look like it is Judge Yellowhorse that did ultimately issue this warrant. It was
Yeah.
from February 23rd of 2023. Just make sure you get there. That way you can find out what's going on, resolve the issue. As you know, it's in Sanders, Arizona. Your hearing will be April 29th at 8:30. If you have written conditions, they'll be in your paperwork, but includes things like not possessing drugs without a valid prescription, not driving a motor vehicle without a valid driver's license, okay? Any questions?
No, ma'am.
All right, please take a step to your left. The officer will get that for you. Mr. Imofia to the podium. George Valencia to the chair. Can I get your name and date of birth?
My name is Ogale Emiofa, 033006.
Thank you, sir. You are here today on a new case. It is for one count of theft, a Class 5 felony. Probable cause has been found, and I am appointing an attorney to represent you. You're going to have a status conference May 8th at 8:30 and a preliminary hearing May 12th at 8:30. I am going to release you today on your own recognizance. That is your promise to appear at these hearings. Will you attend these hearings, sir?
Yes, ma'am.
You do have written conditions. You may not return to the scene of the alleged crime. No contact with any alleged victim, complainant, or witness. And then again, just ensure you attend your hearings. If you fail to appear, a warrant will issue for your arrest, and then you'll be held on bond at your next hearing.
Yes, sir.
Any questions? Please take a step to your left. The officer will get that for you. George Valencia to the podium. Jonathan Espinoza to the chair. May I get your name and date of birth?
George Valencia, 11/15/91.
Thank you, sir. You are here today on a new case. It does look like it relates to, it's a theft charge, a Class 3 felony. Probable cause has been found, and I'm appointing an attorney to represent you. You're going to have a status conference May 8th at 8:30 and a preliminary hearing May 12th at 8:30. At this time, I'm inclined to release you on your own recognizance. That would be your promise to appear. Do you promise to appear at these hearings, sir?
Yes, Your Honor.
You do have written conditions. You're not to return to the scene of any alleged crime, no contact with any alleged victim, complainant, or witness. I will release you, but make sure you attend these hearings. If you fail to appear, a warrant will issue, and then you'll be held on bond at the next hearing. Any questions, sir?
Yeah, my car is at my job that I was at. Do I have to send someone else to go pick it up?
If you could have somebody else pick that up, do you have somebody that could do that for you?
Yeah, because I thought my girlfriend would have picked up the car last night, but I'm pretty sure she didn't, so they have my keys, so I have to just send someone?
Yeah, if you could just coordinate to have the vehicle picked up, that would be best to avoid any issues while this case is pending, okay? All right, if you'll step to your left, the officer will get that for you.
Thank you, Your Honor.
Jonathan Espinoza to the podium. Can I get your name and date of birth?
Jonathan Espinoza, 04/15/95.
Thank you, sir. You are here today on a new case for one count of knowingly displaying a false license plate, a Class 2 misdemeanor. Probable cause has been found. However, due to the nature of your charge, you're not entitled to court-appointed counsel, but you may hire an attorney at your own expense if you would like. You're going to have an arraignment hearing. That'll take place in the Country Meadows Justice Court, May 14th at 8:30 in the morning. I am going to release you today on your own recognizance. That is your promise to appear at this hearing, but you do have written conditions. You're not to possess or consume drugs without a valid prescription. You're not to drive a motor vehicle without a valid driver's license. You'll need to ensure you attend all of your future hearings. If you fail to appear, a warrant will issue, and then you'll likely be held on bond at your next hearing. This will be in your paperwork, sir. Did you have any questions?
No.
Please take a step to your left, and the officer will get that paperwork for you. And officers, I do want to confirm that they gave you the information regarding to Cameron Mills.
Yes, Your Honor.
Okay. So I'm going to proceed by putting our house calls on the record. We do have 3 individuals that will be completed as house calls due to being a danger to self or others. Number 7, Verdiana Valle, date of birth August 15th, 1995, is here on a new case for 1 count of drug paraphernalia possession, a Class 6 felony, 1 count of criminal trespass, a Class 3 misdemeanor. Probable cause has been found, and I'm appointing an attorney to represent her. She is going to have a status conference May 8th at 8:30 and a preliminary hearing May 12th at 8:30. I am releasing her today on her own recognizance. That is her promise to appear. She does have written conditions of release. She may not return to the scene of the alleged crime, and she may not consume or possess any drugs without a valid prescription. All of this will be included in her paperwork. Case number 15 and 16 belong to Glenn Gorman, date of birth March 1st, 1987. He is here on a warrant from the Yavapai County Superior Court and a warrant from the Desert Ridge Justice Court. The Yavapai County Superior Court warrant alleges he violated his probation. I am going to appoint an attorney to represent him, and I am going to set a hearing in Yavapai County Superior Court on April 29th, 2026. And that will take place at 8:30 in the morning. Just one moment while I take a look at this. Okay. In this case, he has a secured appearance bond of $25,000. Case number 15 is from the Desert Ridge Justice Court. It's for failing to appear at a hearing for exceeding the posted speed limit by more than 20 miles per hour. I'm going to set an arraignment hearing on April 29th at 8:30 in the Desert Ridge Justice Court. I'm appointing an attorney and setting a $50 placeholder bond. So he has a total bond of $25,050. In the event he posts bond and is released, he has written conditions. He may not possess weapons or alcohol. He must contact his probation officer within 72 hours. And the last remaining is Richard Clennon, date of birth April 20th, 1979. He is here on 3 cases. He is here on a new case. He is here on a probation violation warrant and a failure to appear bench warrant. His new charges are for 1 count of narcotic drug possession, a Class 4 felony. I am finding probable cause and appointing an attorney to represent him. His probation violation warrant alleges he violated terms 6, 7, and 12. I am appointing an attorney in that case. And his failure to appear warrant alleges he failed to appear at a hearing in March of 2026 for a case with pending charges for dangerous drugs, narcotic drugs, and drug paraphernalia. I'll affirm the attorney previously appointed to represent him in that case. He will have a status conference along with a probation revocation hearing April 30th at 8:30, an evidentiary hearing May 1st at 8:30, and a preliminary hearing May 4th at 8:30. In his probation violation case, he has a secured appearance bond of $750. In his failure to appear case, he has a cash bond of $750. However, on his new charges, because he was out on felony release at the time of this alleged offense, he is not eligible for bond on this case. So posting the other 2 bonds will not get him released. He will need to attend his evidentiary hearing on May 1st at 1:30 to determine if bond will be set on these new charges. This will all be included in his paperwork. If anything changes after I meet with any of these parties, I will update the written record. This does conclude our 8 a.m. calendar. We will now stand in recess until 11 a.m.
$1,000 bond. Did either counsel wish to be heard on?
Yeah, sure. Thank you.
One second, please, sir. All right, your name, please, sir?
Keegan Monjo?
All right, Mr. Monjo, this is the time set for your initial appearance. We're going to go over your charges and release conditions. Before we do that, know that you are presumed innocent. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. All right, I'm going to be appointing the public defender's office in this case. Mr. Monjo, I am seeing you on charges of disorderly conduct. This is a post-indictment matter on CR 20261879. The bond asked for the bond amount was a $5,000 bond. That was my inclination. Does either party wish to be heard?
No, Your Honor.
All right.
Your Honor, just on that, I mean, we see this as a level one nonviolent. We understand that the bond amount was requested at 5,000. We're wondering why we wouldn't go with the statutory presumption of pretrial services on this matter.
Let me pull that up.
We didn't get an interim complaint on this one because it was post indictment, so we just would like to know some of the facts that would underlie that recommendation.
So it looks like Mr. Munger is already in custody on a $75,000 bond. So it makes more sense to hold Mr. Munger to make sure he's getting time credit on these new charges. Even if they predate the one he's on for already, I don't know the dates of them.
Makes sense.
Your Honor, it looks like this is from the $75,000 bond. This case is from that same incident. It's just that they reached out and were contacted by another victim. And this case pertains to this victim, but it's for that same overall incident where $75,000 was accepted.
All right, thank you. So I'll impose a $5,000 cash or secured bond. Mr. Monjo, you have two bonds on you for a total of $80,000 now. No contact, sir, with the alleged victims. If you do post bond, you can't go to any of the alleged victims' residence or workplaces. Your next court date, sir, is going to be in arraignment on May 1st at 1:30 p.m. And with that, sir, you're excused.
Good morning, Your Honor. This is the Spanish speaker. Can we check if we have any Spanish speakers today?
Officer Horn. Can V go?
He's taking somebody out right now. On our court list, it does not appear that we get anybody, but we can double check with them.
You make absolutely.
Thank you.
Jail just confirmed we do not have any Spanish speakers today.
Izzy.
Thank you, Your Honor. Interpreter disconnecting.
Your Honor, I heard you as I was leaving the room. How can I help you, sir?
Making sure you had no Spanish speakers, Mr. Horn.
Yeah, we confirmed that.
I am showing nobody needing the interpreter this morning.
We thought not.
It's nice just to hear you say it.
Manuel Lopez will be next.
Okay.
Love it.
And counsel, I can't remember your name. I'm sorry. I think we've met before, but.
Don't worry about it. My name's Jonathan Michael. Here with Public Defender.
Jonathan Michael, thank you, sir. Yeah, yes, okay, we have that. I'm sorry, sir.
I don't think it is.
Your name, please, sir?
Manuel Andrew Lopez.
All right. Mr. Lopez, we're here on a review hearing. It looks like you got a current Pima County case as well as a Bisbee case. We just want to make sure that we don't lose you in Pima County Jail, so that once your Pima County Jail case is done, we want to make sure that either Bisbee gets you or you're released, sir, okay? So the bond's going to remain the same. We're going to set a review hearing for May 26th, just in case you're still in the jail, even though you're finished with your Pima County case. All right, sir? Make sense, sir?
I thought the case was already finished though. On the
Pima County case?
Yeah, because that's what we came for the last court.
What happened? Let me take a look, sir. Hold on. I can tell you that.
Yeah, 72 hours.
Yeah, it looks like you're only being held on out-of-county justice court matters. When was your Pima County case resolved?
It was resolved last Monday when I came to court with you.
Oh, that's right.
And you told me I had 72 hours for Bisbee to come get me.
I remember that now, and now it's Friday.
Yeah, and you told me that you're gonna let me go if they didn't come get me.
Yeah, why didn't they come and get you? Give us 1 minute, Mr. Lopez.
Okay.
Hey, Officer Horn, let's bring back Mr. Lopez. He has a good question, and I want to make sure I have an answer for him. Can we bring him back at the end of the calendar?
Let's see.
Your name, please, sir?
Benito Vidal.
Give me 1 second, sir.
Okay.
Mr. Vidal, this is the time set for your initial appearance. We're going to go over your charges as well as release conditions. Oh, hold on, sir.
Yeah, if we could go over everything, that would be fine because when I came in, I was going through detox and I don't remember much and I want to make sure I know what's going on. If you don't mind, that would be awesome. Please and thank you.
Sure. All right, sir. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, sir. I'm going to appoint the public defender's office to represent you, sir. You are here today, sir, on 1 charge of burglary in the 3rd degree. That's a felony, as well as 4 misdemeanor charges for possession of paraphernalia, shoplifting, criminal damage, and then a failure to appear, sir. The state.
I'm going to get that. I'm sorry.
The state's asking me to hold you on a $2,500 bond plus pretrial services. My inclination, counsel, was a $1,000 bond. Does either party wish to be heard?
No, Your Honor.
No, and we appreciate you going lower than the state's recommendation. We were hoping that, I mean, if there was any way to go even lower on that range in your mind, just because of his age, his community ties, his low means, that he has transport confirmed, and then he did say that he is detoxing, which might explain some of the confusion underlying this.
I also have a job. I still work.
Given.
I also have a job, Your Honor. I work for Tailor Made Janitorial Services. So I also have a job.
Yeah, for Mr. Vidal, their pretrial services is indicating he has a failure to appear in city court. I don't have a city court file for him.
He was seen on that yesterday.
Oh, was he?
Yeah, he was continued for the JP stuff, but the judge kept the order.
What was the order on the city court stuff?
I think he was all like.
Let me pull it up too. I can pull it up. So usually I have all of the cases in front of me. It sounds like you were seen on the city court case, but not on. All right, yeah. So you're being held on a $250 bond right now on the city court case for the failure to appear, sir. I'll lower this bond to $500, sir, cash or secured. You're going to have court, sir, May 4th at 1:30 p.m. And that will be pretrial services, sir, if you post bond. Do not return to the incident location, sir, where you're alleged to have committed the burglary. And no contact with the victim of the property where you're alleged to have committed the burglary. And with that, sir, your excuse, sir. Can someone?
We are rounding up the misdemeanors and we'll level up soon.
Thank you, Jonathan. I feel like that's got to be pretty close to now.
We're ready to go.
It is the 16th, huh? Yeah. All right, give me 1 second, sir.
Okay.
So.
All right, ladies and gentlemen, you are all here for your initial appearance. We're going to go over your charges as well as your release conditions. Before we do that, know that you are presumed innocent. You have the right to remain silent. I'm sorry, Jonathan, are they all there?
They're on. I was letting them know to listen.
Thank you. All right. You are all presumed innocent. You have the right to remain silent. Anything you say can't be used against you. You have the right to hire an attorney. In some instances, I might be appointing you an attorney. Before I go over your charges and release conditions, know that I've reviewed information from law enforcement as well as pretrial services if they have spoken to you. Sir, what's your name, please?
Hector Blumenkraut.
All right, Mr. Blumenkorn, I'm seeing you, Blumenkron, sorry. I'm seeing you on a justice court case as well as a city court case, sir. On the justice court case, I'm seeing you on one charge of driving with a suspended license. On the city court case, sir, I'm seeing you on one charge of failing to appear for an assault and disorderly conduct charge, sir. Give me 1 second to review the city court case.
That's all right.
Hold on, sir, don't say anything yet. Sir, I'm going to release you on your promise to go to court. Will you go to court on May 19th for the justice court case? And will you go to court on May 19th for the city court case? That's good news. Can you do that, sir?
Yes, sir.
All right. So for justice court, this is your driving on a suspended license, sir. You're going to have court on May 19th at 9 a.m. in front of Judge Steele. All right.
Okay.
On the city court case, sir, you're going to have court on May 19th, the same day, but at 2:30 p.m. in Tucson City Court. So just block that day up for court hearing, sir.
Okay.
Oh, well, sir, I want to see how old this case is. This is a pretty old case. All right. Sir, let me enter pleas of not guilty on your behalf on the city court case. This is your arraignment. And advise you, sir, that because it's your arraignment, if you do not show up to that hearing, a warrant can issue for your arrest. Trial can go forward in your absence. Further, if you're convicted at trial and don't appear for sentencing within 90 days, you can lose your right to appeal, sir. Understood?
Okay, sir.
All right, sir. Take care.
Thank you.
Thank you.
Thank you. Yes. For the thing.
That's it. Back here. Hey. You're gonna go all the way up, far left hand side of the void, sir. Out, wonderful. Yeah, down the stairs, far left hand side.
Your name, please?
Jennifer Haig.
All right, Ms. Haig. I am seeing you on 2 justice court matters, ma'am. One is for possession of paraphernalia and criminal trespass. And one is for failing to appear for a charge of possession of paraphernalia. Ma'am, if I release you, will you go to court on May 21st?
Yes, sir, I will.
I'm going to release you, ma'am. You're going to have court May 21st in Pima County Justice Court at 10 a.m. in front of Judge Pesquera.
Thank you, sir. Thank you. Thank you.
Good one.
Hold on, sir. I'm gonna. Have a seat, have a seat, have a seat. Sir Perkins? Let's see, right there.
Your name, please, sir. Your name, please, sir.
Your name? What's your name, sir?
Cheerio.
You want to talk to the judge? He's asking your name.
Sir,
What's your name?
Can you give me your name, sir?
No.
Okay, you don't want to? All right. Well, sir, in order to do your arraignment, I'm going to need to make sure you are Jacob John Perkins. Will you affirm that you are known as Jacob John Perkins?
Yeah.
You will. Okay. I'll take that as a yes. Sir, I'm seeing you on 2 justice court cases. One is for domestic violence assault, domestic violence disorderly conduct, and resisting arrest. The other is for failing to appear on a charge of criminal damage. On the failing to appear, sir, I'm going to hold you on a bond of $500 cash as secured. Set court for April 27th at 1 p.m. Order no contact with the alleged victims of that case and appoint Alexander Ball to represent you, sir. On the new charges, sir, I'm going to hold you on a bond of $1,000 cash. Again, appoint Alexander Ball and set court, sir, for April 27th at 1 p.m. in Pima County Justice Court. Again, no contact with any of the alleged victims, sir. And with that, sir, you're excused.
Michelle? Perkins? No. No, yes. Go that way. This way.
Your name, please?
Matthew Rochelle.
Mr. Rochelle, I'm seeing you on charges of driving unsuspended license and possession of paraphernalia. Sir, if I order you to appear at court on May 19th, will you do that?
Absolutely.
All right, we'll set court, sir, for May 19th at 9 a.m. in front of Judge Garza, Pima County Justice Court. I'm going to release you, sir, on your promise to go to that court date, okay?
Thank you, sir.
All right, so you're excused.
Animal.
Yes. Good morning.
Good morning, sir.
Your name, please, sir?
Ernesto Sandoval, sir.
Mr. Sandoval, I'm seeing you on charges of domestic violence, criminal damage, 2 counts of that. Sir, if I order no contact with the alleged victim and you may not go back to her residence, her workplace, or the incident location, will you agree to those conditions?
Yes, sir, I will, sir.
All right. Do you have belongings at her house?
Yes, I do, sir.
All right.
Just a bag of clothes and stuff, but I'm not worried about it right now.
Well, I'm gonna order that you may return once with a law enforcement escort to pick up those belongings, but you're gonna have to call law enforcement and let them know that you need to pick up belongings with an escort, okay? You can't just show up there, understood?
Yes, sir. Understood.
This is effectively a no contact order or a restraining order, okay, sir?
Yes, sir.
If you go to her house or have any contact with her, even a text message, and she calls the police, you can be arrested for violating a no contact order, okay, sir?
Yes, sir.
All right. I'll release you, sir, on your promise to go to court then. Your court date, sir, will be May 19th at 9 a.m. in front of Judge Pesquera. That's in Pima County Justice Court, sir. And with that, sir, you're excused.
Thank you. Yes, sir.
Ashley?
All right, your name, please, ma'am?
Ashley Barnes.
Ms. Barnes, I'm seeing you on one city court case. Charge of criminal damage and disorderly conduct. Ma'am, I'm going to release you on your promise to go to court on May 26th at 1:30 p.m. in front of Judge Millian. No contact with the victim. Do not go back to their location. I believe you indicated you didn't plan to. Do you have belongings there, ma'am?
Yes, sir.
I'm going to order that you can go back once with a law enforcement escort to pick up any belongings you have, okay? Because you did indicate you were not going to go back there, right, ma'am? That you have somewhere else to live?
Yeah.
Okay, great. All right, ma'am. With that, then you're excused.
Thank you.
Your name, please?
Brianna Galas.
I'm sorry, say that again, ma'am?
Brianna Galas.
Yeah, it looks like we're gonna skip one.
Yeah. All right, Ms. Galaz, I am seeing you on charges of, I'm seeing you on a number of city court charges, ma'am. These are all failure to appears for, actually, I think I have new charges as well. Yeah, so I've got new charges, ma'am, of theft and possession of paraphernalia, and then failure to appears or comply with charges of disorderly conduct, reckless burning, criminal trespass, shoplifting, and paraphernalia. Ma'am, I'm gonna hold you on a $500 cash or secured bond. Set your court date for April 30th. That's in 6 days with Judge Blue in Pima County, sorry, in Tucson City Court. I'm gonna order that you do not go back to any location where you've been trespassed from or where you've been alleged to have shoplifted from, okay, ma'am? And appoint the city PD.
What's the time on that hearing, sir?
Thanks, Jonathan. The time for that hearing is 1:45 p.m.
Thank you.
I'm going to enter pleas of not guilty on your behalf, ma'am. And with that, you're excused, ma'am.
Jeffries?
Your name, please? Your name, please, sir?
Christopher Jeffries.
Mr. Jeffries, I'm seeing you on a number of criminal damage and disorderly conduct charges. 1 second, sir.
Yes, sir. Oh my God. I've been better. Hope I get out of here, man. Go find my dog at Pag.
All right, so sir, I've got some old charges and new charges. I've got disorderly conduct and criminal damage from June of 25, as well as disorderly conduct and criminal damage from April 26. Sir, I'm going to hold you on a $250 cash or secured bond. Set a court date, sir, for May 1st in front of Judge Verena at 1:45 p.m. in order no. No, sorry, sir. Order no contact with the alleged victim, sir. You may return home, but I have given the alleged victim an opportunity to return with law enforcement to get any required belongings.
That's good.
With that, please not guilty, sir. With that, you're excused.
I'm sorry. So what was the bond amount?
250, cash or secure.
And I got paid 10%.
Your name, please?
Lopez.
So Lopez, I'm seeing you on a lot of city court cases, man. New charges of domestic violence assault, disorderly conduct, criminal trespass, and criminal damage, and some failure to appear, sir, for assault, disorderly conduct, criminal trespass, and criminal damage. Sir, I'm going to hold you on a $1,000 cash bond. Order no contact with any alleged victims. Do not go to any of the victims' residence, workplaces, or incident locations. Set this in front of Judge Millian on May 13th at 1:30 p.m. and enter pleas of not guilty. I'm also going to appoint the city PD, sir, to represent you in these matters. And with that, sir, you're excused.
Your Honor, I'm actually gonna adjust those dates to
Great.
May 6th, because it's
Great. Yeah, thank you. Thank you.
Now we're gonna do Fikes.
Thank
Your
you.
Honor.
Thank you.
Counsel, Mr. Fikes isn't gonna make it.
Okay. Looks like Fikes is gonna make it today. Your Honor.
We'll see her tonight then.
Him. Oh, Taylor. That's it. Counsel, we're gonna start with the penalties and go back to steps.
PM. Yep. Are we doing the keep separates now?
You know, it sounded like Warren was saying we were doing felonies before keep separates, but I'm gonna check with him when he walks back in. He's getting his cardio this morning.
He's on IPS, so we can't. Your name, please?
No, so this is the start of the felonies, but to keep separate.
So
Is this?
So we are going to be doing keep separates first. Turns out it's going to be Escobar.
All right. So are you Joshua Escobar?
Yes, sir.
Sorry.
Good morning. Sorry.
Good, sir. Sir, this is the time set for your initial appearance. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. Mr. Escobar, I'm going to be appointing the public defender's office to represent you, sir. Counsel, I have a grand jury warrant for a $1 million cash bond. Does either party wish to be heard with regards to whether I impose that bond?
No, Your Honor, I'll submit on my recommendation.
No, Your Honor.
All right. Sir, I'm going to impose that bond, order no contact with the alleged victims. You may not go to their or if you are able to post that bond or are later released. Your court date, sir, is May 4th at 1:30 p.m. That court date's unlikely to go, sir, so please speak to your attorney about what to expect in the next few weeks, sir. And with that, sir, you're excused. Thank you. Yeah. I thought that was too long. Yeah, I thought that was too long. All right. Thank you. Your name, please?
Arturo Gonzalez.
Gonzalez, this is the time set for initial appearance. We're going to go over your charges as well as conditions of release. Before we do that, know that you're presumed innocent. You have the right to remain silent. Anything you say can't be used against you. I'm going to appoint the legal defender's office to represent you in this case, sir. The state's asking for a $200,000 cash or secured bond. Mr. Michael, did you want to be heard, sir?
Yes, just briefly. I mean, we understand the allegations are serious. I know that you've already looked at all of it, but for the record, just he's 21 years old, lifelong Tucsonan, and he has bullying family, home, and transport. So we're just asking that the bond be reduced in light of those factors.
Thank you, counsel.
So Mr. Gonzalez also let me know that he's part of a goodwill reentry program that can corroborate that and cooperate with PTS at any point.
Thank you, sir. Thank you, sir. Given the interim complaint and the risk to the community, I do think that Mr. Mosier's request is reasonable. I am going to hold you, sir, on a $200,000 cash or secured bond. You'll have no contact with any of the alleged victims. You cannot go to any of their residences, workplaces, or back to the incident location, sir, if you post that bond or are later released. Next court date, sir, is May 4th at 1:30 p.m. That court date, sir, is unlikely to go, so please speak to your attorney regarding what to expect over the next few weeks. With that, sir, you're excused.
Spurlock. Under. Turn to your left, judge in front.
Morning.
Your name, please, sir?
Austin Spurlock.
Mr. Furlock, this is the time set for your initial appearance. We're going to go over your charges as well as conditions of release. Before we do that, know that you're presumed innocent. You have the right to remain silent. Anything you say can be used against you. I'm going to appoint the public defender's office, sir, to represent you in these charges. You also have an attorney sitting next to you to assist you right now. Sir, I'm seeing you on charges of 2 counts of aggravated assault, armed robbery, and theft of means of transportation. The state's asking for a $200,000 bond. Mr. Michael, do you want to be heard, sir?
Only that Mr. Spurlock is the youngest of the group, and so we're asking that maybe the bond could reflect that, but we understand the court's decision.
Mr. Spurlock, I think that given the interim complaint, there does seem to be a risk to the community. I am going to hold you on that $200,000 request by the state. Order no contact with any alleged victim. If you post that bond or are later released, sir, you cannot go to any victim's residence, workplace, or even back to the incident location. Your next court date, sir, is May 4th at 1:30 p.m. That court date, sir, is unlikely to go, so please speak to your attorney about what to expect over the next few weeks. And with that, sir, you're excused.
Thank you, Your Honor.
Sir.
So I come to jail.
Yeah.
So I talked to the sergeant, and right now in their system, they don't have an active warrant or even one. So they're gonna try to call Coaching PD to
Thanks.
see if it was still
Yeah.
there, and then they're gonna call me back right now.
Thank
to
you.
see if they can-
Thank you, Ken. Thank you, Ken.
Your Honor, was Rochelle, is there any, was that a convenience?
I think I released her. Didn't she have 2?
Yeah, two cases out of the city.
I released her.
Okay.
Sorry. Yeah. I'm really bad at doing multiple
Yeah, I guess.
complaints, man. Yeah.
Sure. Thank you.
And for both counsel, we're looking into the issue with Mr. Lopez. I don't know if
Thank
you have any information, Mr. Mosier. He's on IPS. He was given a 60-day jail sentence. He should have been released on April 19th to IPS unless Cochise County was going to come pick him up. I don't know why he's still in the Pima County Jail. But we're trying to investigate.
Thank you.
Thank you, Your Honor.
Good morning.
Your name, please, sir.
Dean Attaway, the third.
Thank you. Thank you, Mr. Attaway. Jonathan, do we have all the felonies in the courtroom now, sir?
Yes, although if you want to make an announcement, just wait 1 second because it's kind of noisy.
Yeah, thank you. I will do.
Or do you want to let him know that he's going to make an announcement for everybody? We're ready for you, Judge.
Thank you very much, Mr. Michael. Ladies and gentlemen, this is the time set for your initial appearance. We're going to go over your charges as well as your release conditions. Before we do that, let me go over a few things. First, you are presumed innocent. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. Second, on that, I'm going to be appointing an attorney for all the felony matters. When you come before me, I'll let you know who that is. You also have an attorney sitting next to you, Mr. Michael, to assist you today. And the state's being represented by Mr. Mosier. He is present over Microsoft Teams. Third, before I go over your charges and conditions of release, know that I've reviewed information from pretrial services, from law enforcement, and I'll be taking arguments from both the state and your counsel. Mr. Attaway, are you ready, sir?
Yes, sir.
Is your name Dean Attaway?
Yes, sir.
I am seeing you, sir, on charges of aggravated DUI, felony criminal damage ×3, felony endangerment ×2, and fleeing the scene of a collision with injuries, also narcotic drug possession and possession of paraphernalia. Sir, the state's asking for a $75,000 bond. Counsel, my inclination was a $35,000 bond. Does either party wish to be heard?
No, Your Honor.
We agree with your equation.
Mr. Attaway, I'm going to hold you on that $35,000 cash or secured bond, sir. No contact with the alleged victims, and you may not go to their residence or workplace if you do post bond or are otherwise released. And with that, sir, you are excused.
You're right.
May 4th. I'm sorry, Mr. Michael. The court date, sir, is May 4th. Sir, that court date's unlikely to go, so please speak to your counsel regarding what to expect of the intervening weeks.
And was it the public defender that you appointed?
It was, Mr. Michael. Thank you.
Thank you very much.
Your Honor, I'm going to continue this case.
Yeah. Your name, please, sir.
Carlos De La Osa.
De La Osa. You are being seen, sir, on charges of possession of paraphernalia, possession of a dangerous drug, and possession of a narcotic drug. Sir, the state's asking for release to pretrial services. That was my inclination. Sir, have you heard of the STEPS program?
Heard of what?
The STEPS program.
No, I have not.
All right, let me go over it then, sir. The STEPS program is a joint program between the county attorney's office and the courthouse. The county attorney's office will agree to dismiss charges if you do drug treatment and counseling required by the court. Are you interested in that?
Yes.
All right. I'm going to set a screening then, sir, for May 1st at 9 a.m. Mr. Michael, do we have time?
Yes.
All right. I've just asked your attorney, sir, if he waives time for the state to decide whether or not to charge you. He said yes. So we're going to set your preliminary hearing, sir, for June 8th. The most important date right now, sir, is that May 1st court date. If you do not go to the Pima County Superior Court on May 1st at 9 a.m., you will not be eligible for this STEPS program, okay?
Okay.
And appoint the PD's office if I didn't say so already, sir, and release you to pretrial services. Any questions, sir?
No, sir.
All right, sir. You're excused.
Thank you.
Okay.
Yeah.
But our jail says they have to. They're gonna try to contact them again.
By 5 p.m. today then. That's good. Okay, thanks.
Fellows. Yeah.
Thank you.
Your name, please, sir?
Raishan Embry.
Mr. Embry, I'm seeing you in a couple cases. One is possession of a deadly weapon by a prohibited possessor. I'm also seeing you on a city court case for disorderly conduct and assault. The state, sir, on the felony charge is asking for a $1,000 bond. That's a relatively reasonably low bond given the charges. Mr. Michael, though, did you want to be heard, sir?
Yes, Your Honor. We think while that is a reasonable request, we think given the lack of criminal history, the fact that he's unemployed, his youth, and that his family has agreed to provide residence and transport, We think that a lower bond would be appropriate. We even think that he would be a good candidate for trust services.
Give me 1 second, Mr. Michael. I'm reviewing the city court case, but I hear you. Thank you, sir. All right. Given the failure to appear on the domestic violence charge in Tucson City Court, I think that bond is reasonable. I am going to hold you, sir, on a $1,000 cash or secured bond. Your court date, sir, will be May 14th at 1:30 p.m. And the public defender, sir, is appointed. On the city court case, sir, to make sure you're getting time credit, I'm going to hold you on a $500 cash or secured bond.
I got a question.
Why don't you ask Mr. Michael first, sir? Sorry. Yeah.
We're good to go, Your Honor.
Mr. Embry, on the city court case, like I said, $500 cash is secured. No contact with the alleged victim in that case. You cannot go back to her residence or her workplace. I'm going to appoint the city PD to represent you on that city court case, sir, and set court for May 1st at 1:45 p.m. in front of Judge Maldonado. And enter pleas of not guilty on your behalf, sir. And with that, sir, you're excused.
Well,
Oh, jeez. It was that bad.
Garcia Felix.
thanks for your patience, Your Honor. We don't have the little fancy cards in English, so I'm having to write some things down.
No worries. Your name, please, ma'am?
Carla Garcia.
Ms. Garcia, I'm seeing you on charges of possession of a narcotic drug for sale, possession of a narcotic drug, transport for sale, and possession of paraphernalia. Law enforcement, ma'am, is asking me to impose a high bond on you. The state's asking for a $25,000 bond. Counsel, given the amount of drugs that were alleged to have been in Ms. Garcia's possession, my inclination was a $25,000 cash bond. Does other party wish to be heard?
No, Your Honor, I would support that.
Judge, this is Matt Eklund with the Attorney General's office. Sorry, we received this as a referral this morning. I would certainly concur with a $25,000 bond.
We would ask the court to reconsider just because of the lack of criminal history, no felony history, the family and long residence in Tucson, as well as having 3 dependents, and this being a level 1 nonviolent felony, which is a statutory presumption of pretrial services. So we understand the severity of the allegations, but we hope that that does counterbalance.
So just so you all know where I'm coming from, a ballpark figure for the street value of the drugs is around $20,000. That's why I'm going to impose a $25,000 cash bond. Ma'am, I'm going to appoint the PD's office to represent you and set court, ma'am, for May 4th at 1:30 p.m. And with that, ma'am, you're excused.
Thank you, Judge. Have a good morning.
Thank you, Mr. Eklund.
Dials. All the way up, man. Or right hand side, please.
Your name, please, sir?
Christopher Shane Giles.
All right, Mr. Giles, I'm seeing you on charges of possession of a narcotic drug for sale, possession of drug paraphernalia, and resisting arrest, sir. The state, sir, is asking for a $35,000 bond. Both counsel, my inclination was a $25,000 cash or secured bond. Does either party wish to be heard?
No, Your Honor.
Your Honor, we appreciate you lowering the bond from the state's recommendation. I'm guessing you did that because of his low means. We think just because of that low means, even $35,000 is completely out. So we're asking for slightly lower.
I've got concerns with the risk to reoffend, just given that Mr. Giles, you were allegedly to be paroled and you finished your sentence in September, and now we have new charges. So I think the $25,000 cash and secured bond is appropriate. I'm going to appoint the PD's office, set court for May 4th at 1:30 p.m. Mr. Giles, that court date is unlikely to go, sir, so please speak to your attorney about what you expect over the next few weeks. With that, your excuse, sir.
Fuller.
Your name, please.
Christopher Fuller.
Mr. Polar, I'm seeing you on charges of possession of a dangerous drug and possession of drug paraphernalia. The state's asking for a $500 bond. Counsel, my inclination was to release Mr. Kohler to pretrial services instead of steps hearing. Mr. Mosher, do you want to be heard, sir?
No, I was struggling with that recommendations, and I'm okay with that.
Mr. Kohler, have you now heard of the steps program, sir? I know I went over in the jail. I'm not sure if you were listening.
I have heard of it, yes.
Are you interested in that, sir?
Yes.
I'm going to set a steps hearing, sir, for April 29th. Mr. Michael, I assume you waive time?
Yes, sir.
We'll set a PH, sir, for June 8th. Don't concern yourselves right now with that June 8th date, sir. Concern yourself with the April 29th date. If you do not go to Superior Court at 9 a.m. on April 29th, you will not be eligible for this diversion steps program, sir, okay? And we'll release you to pretrial services and appoint the legal defender's office to represent you, sir. And with that, sir, you're excused.
Thank you. Thank you. Thank you.
Your name, please?
Lana Marie Montano.
Montano. I am suing you on a Pinal County warrant. You must also be in the jail on a Pima County matter. Is that correct?
On a Pima County, I don't know.
Okay, hold on, ma'am. So no, this is your first time being seen. All right. Ma'am, Pinal is asking me to impose a $5,000 bond. I'm going to do that. They have 72 hours to come and get you, ma'am, before that bond reverts to release on your promise to appear status. All right, ma'am? So if
Okay.
within 72 hours, you will be released. Give me 1 second, ma'am. I'm going to set a review hearing, ma'am, on April 1st, just to make sure that you're not still in the jail. And
Okay.
Sorry for the question, Your Honor, but why is the hearing set on the 1st of May if she has until the 27th of April to get released?
I can modify that.
Okay, thank you.
Let's go to the date, Mr. Michael. That's a good point. Let me go back. I'll set it for the 28th. All right, ma'am. I'll set that review hearing for the 28th.
Thank you.
Am I still eligible to try?
You can post bond, ma'am.
Yes.
If you post bond, ma'am, you just got to get yourself to Pinal County. Otherwise, you risk losing that bond.
Okay.
Wait, I think I just gave you the wrong one. Yeah. Mr. Michael, what are we waiting for? Is this?
Oh, wait, no, we're waiting.
Oh, who's done? I'm sorry. Yeah, she's finished.
Okay.
Sorry, yeah.
Hey, when you move, we move.
I don't do Fridays. My brain's not here yet. Your name, please, ma'am?
Ryan Moore.
Ms. Moore, I'm putting you on charges of criminal trespass, possession of paraphernalia, and possession of stolen property. Ma'am, state asking our release to pretrial services. That was my inclination. I don't believe your attorney is going to have any objection to that. I'm going to set.
Your Honor, I actually have a better recommendation than that. I'm going to move to dismiss this without prejudice.
All right, Ms. Moore, that's good news for you, ma'am. So the state's asked me to dismiss this without prejudice. I'm going to do that. Ma'am?
I'm good.
Yes.
When you're released from the jail pretty soon, I don't know if you need help or want any resources, ma'am. There is a transition center attached to the jail. If you follow the blue line when you're released, you'll walk into a trailer, and that trailer has a lot of resources that you might find beneficial, even someone to talk to, ma'am. However, regardless, this case is now dismissed. They can bring it back in 7 years if they want to, within 7 years. But for now, it's dismissed, ma'am.
Thank you.
Ma'am, you're excused.
New bro.
Your name, please, sir?
Samuel Winston Newbro.
All right, Mr. Newbro, I'm seeing you on charges of organized retail theft, sir. There's a bond amount set by a Pima County judge asking for a $500 bond because of the times that you have not shown up to court. The state's asking me to impose a $1,000 bond. To be honest, Mr. Michael, that was actually my inclination to raise Judge Monroe's bond recommendation to 1,000, just given the opportunities Mr. Newbro's had while released to pretrial supervision and not come to court. But I will absolutely listen to you, Mr. Michael.
No, Your Honor, we don't have any argument.
All right. Mr. Newbro, I'm going to hold you on that $1,000 cash secured bond. Set court, sir, for May 1st at 1:30 p.m. and appoint the PD's office to represent you. That court date, sir, will go, sir. It's going to be a video arraignment. All right, sir?
Thank you.
Yeah. For who?
Are we good to go, Your Honor?
Yeah, I'm sorry, Mr. Michael. Yeah.
Thank you.
Oliver? Are you waiting for me to say excused?
I think so. Yeah.
Throwing us off, Judge. When I'm done talking, you're excused, man. I don't stick around for me to say you're done. Give me 1 second, folks. Louisa, Your name, please?
Dylan Oliver.
Mr. Oliver, I'm seeing you on charges of a person under 21 driving a motor vehicle with spirited liquor in body. That's a class 1 misdemeanor. I'm also seeing you, sir, on a charge of criminal damage, which I believe is the class 6 felony. Let me double check. Yes. And, sir, failure to stop at an accident with damage to an unattended vehicle. Sir, the state's asking that I release you on your promise to appear. That was my inclination. I don't believe Mr. Michael will have any objection. So, sir, I am going to release you on your promise to go to court. Sorry, I'm going to release you to pretrial services, which is essentially your promise to go to court, but you got to check in with pretrial services, sir, okay?
Sir.
You're going to have court, sir, on May 14th at 1:30 p.m. Sir, you can't go back to the incident location, all right?
Yes, sir.
All right, I'm going to appoint the PD's office to represent you. And with that, sir, you are excused.
Thank you.
Is that better, Mr. Michael?
Yes, Your Honor. Here. Thank you.
Olson?
Hello, Judge.
Your name, sir?
David Olson.
Mr. Olson, I'm seeing you on a few different cases, sir. On a felony charge of possession of a dangerous drug and possession of drug paraphernalia. I'm also seeing you on, looks like 5 city court charges, sir. These are charges of failing to appear for multiple counts of theft and shoplifting.
So after those, oh wait.
I'd talk to Mr. Michael first before you say anything, sir. All right, counsel, my inclination largely, given the, it's 5 city court warrants for theft. My inclination is to hold Mr. Olson on dollar bond.
Okay.
You want to be heard, sir?
Well, as far as the failures to appear go, I'm sure the court that was for matters that he already gone to prison for. He was released in 2025. So we're not entirely sure how this.
Well, I don't think he's gone to prison for these are 5 counts of city court shoplifting, so I don't think he's gone to prison for that. I don't know if he's in jail or not for any of these, but I would be surprised if he got sentenced to jail and still had warrants out for his arrest. He's going to have an opportunity though to speak to Judge Mayhew about that on May 1st. Let me start with the city court case, sir. You're going to have a city court hearing on May 1st at 1:45 p.m. It'll be in front of Judge Mayhew. I'm going to appoint the city PD to represent you, sir. If you have done jail on any of these, if you have completed them, then the city PD will be able to make sure that you're not being double punished for any of these. I'm going to hold you, sir, on the city court cases on a $500 cash or secured bond in order you not to go back to any of the incident locations where you're alleged to have committed a shoplifting. On the felony case, I am inclined to hold you on a $1,000 bond, sir, and set a steps. Sir, have you heard of the STEPS program now?
No, sorry. I'm not.
The STEPS program is a program run jointly by the county attorney's office and the courthouse. It allows the county attorney's office to dismiss charges if you do drug treatment and counseling required by the courthouse. Are you interested in that, sir?
Oh yeah. Let's do that, please.
Yeah, I'll do a step screening, sir, for May 1st at 9 a.m. I'm going to do a preliminary hearing on May 4th at 1:30 p.m. If you don't go to that screening, sir, on May 1st, if you post, sir, start over. So you got 2 bonds, sir, 1,000 and 500. If you post those bonds, you've got to get to the Superior Courthouse by May 1st at 9 a.m. If you don't post bonds and the jail wakes you up to bring you to court on May 1st, I'd suggest you go because that will be your steps screening date. I am going to appoint the PD's office to represent you. They can assist you in determining whether or not you're going to be steps eligible if you're held and set that preliminary hearing for May 4th. That's the state's date to decide whether they want to indict you on felony charges, sir. And with that, sir, you're excused. Your name, please, ma'am?
Cynthia Pimentel.
Ms. Pimentel, I'm seeing you on charges of possession of dangerous drugs, possession of narcotic drugs, and possession of dangerous drugs and narcotic drugs and paraphernalia. The state's asking for your release to pretrial services. That was my inclination, ma'am. Release you to pretrial services with the STEPS screening date. Ma'am, have you now heard of the STEPS program?
Yeah.
Are you interested in that, ma'am?
Yeah.
All right. I'm going to do a STEPS screening, ma'am, on May 1st at 9 a.m. I'm going to do a preliminary hearing on June 8th at 1:30 p.m. I'm going to appoint the PD's office. Ma'am, you have to get yourself to Pima County Superior Court by 9 a.m. on May 1st if you even want to be considered for the STEPS program, okay?
Okay.
Can you do that?
Yes.
All right. I've also got you for a justice court case, ma'am. Because I'm releasing you on that felony case, ma'am. You had one failure to appear for a charge of shoplifting. Only one. I'm going to release you, ma'am, with another opportunity to try again. You have to go to this court date, ma'am, on May 19th at 9 a.m. So 2 court dates, and Mr. Michael is running them both down for you. May 1st and May 19th. One's in Superior Court. That's the early one. The other one is in Pima County Justice Court in front of Judge Pescara. Okay?
Okay.
All right, ma'am. With that, you're excused.
Thank you.
Mark, you reached that.
All right. Thank you.
Your name, please, sir.
Mark E. Richmond, Your Honor.
Mr. Richmond, I am seeing you on one charge of domestic violence, aggravated assault, strangulation. The state, sir, is asking for a $20,000 bond. Counsel, my inclination was a $10,000 bond. Does either party wish to be heard?
No, Your Honor.
We agree with your inclination.
All right. Sir, that's a $10,000 cash and secured bond. Court date of May 4th at 1:30 p.m. No contact with the alleged victim. You may not go back to her residence or her workplace. I will appoint the PD's office to represent you. Sir, that court date may go. Please speak to your attorney regarding the May 4th court date to understand what's going to happen next. And with that, sir, you're excused.
Yes, sir.
Your name, please, ma'am?
Yes, sir.
Sir, I'm seeing you on one charge of domestic violence, disorderly conduct. State asking I release you to pretrial services. That was my inclination. I don't believe your attorney's going to object. Here's my only caveat, ma'am. Well, I guess I've got 2. One, you can't possess firearms or weapons. You've got to surrender any firearms in your possession to TPD or PCSO within 24 hours of your release. I am going to appoint the public defender's office to represent you. Ma'am, I'm also going to order that you may return home, but if either of the alleged victims does not want you there or does not want contact, you have to leave and go somewhere else. All right? I'm going to set court, ma'am, for May 4th at 1:30 p.m. That court date may or may not go. Please speak to your attorney as well as pretrial services, who I'm releasing you to, regarding your next court date, ma'am. And with that, you're excused, ma'am.
Thank you so much.
Thank you.
All right, Jay, let's bring back Mr. Lopez.
Today.
All right.
Your partner attorney, I'll be there to you.
First,
Thank you so much. No problem at all. Good luck to you, really.
thank you.
All right, Mr. Lopez. I'm not sure why you have not been picked up yet. I don't know if DPS is going to pick you up today. That being said, you've been held in the jail longer than you should have been held. You are on intensive probation services with the Pima County case. I will release you on this case. You're going to be ordered, sir, to call Cochise County Superior Court when you're released, sir, as well as your probation officer. You'll need to make your way over to Cochise County, sir, to deal with these cases, but I will release you today, sir.
Okay,
All right, sir, you're excused.
thank you, sir. Judge, I believe that's it.
Yep. Thanks, everybody. Have a
Thank
good
you.
Friday.
So for purposes of this hearing only, the court does not find probable cause for the property damage allegation. It does not mean it is dismissed. It just means I am ignoring it for purposes of release condition. I am appointing a lawyer to represent you. You and your lawyer will be able to go over what the prosecutor decides to file or not file in your case. This is just these are your arrest charges. So I am appointing a lawyer. Your lawyer can explain more to you about how this works. I'm scheduling your next two court dates. The first one will be a status conference on April 30th at 8:30 in the morning, which is this coming Thursday, April 30th, 8:30 in the morning. Your preliminary hearing will be the following week on May 4th, 30 in the morning. The court address in downtown Phoenix will be on your paperwork. You are also here on a misdemeanor warrant issued by the North Valley Justice Court, because it appears that when you were arrested on May 2nd of 2022, you were originally accused of aggravated DUI by wrong way driving, which is a felony. But when the county attorney charged your case, they chose to bring the case as misdemeanor DUI. So you got charged in the North Valley Justice Court with 2 counts of driving under the influence of alcohol, both alleged to have been committed May 2nd, 2022. It's the same incident. They just accuse you of violating the law in 2 different ways that day. Each of those is a Class 1 misdemeanor. And then they did not have a working address for you, so that became a warrant for your arrest. I am appointing a lawyer for you in the misdemeanor court as well, because you do face some mandatory jail time in that misdemeanor case as well. Your arraignment hearing will be in the North Valley Justice Court on April 29th. So this coming Wednesday, April 29th, 8:30 in the morning, in the North Valley Justice Court. That is your next court date for the misdemeanor case from 2022. That court address will also be on your paperwork. Based on what's been alleged against you in the new case, the court is very concerned that you pose a risk to people in the community because of repeated drunk driving and possible alcoholism. Bond is set in your new felony case at $2,500 secured, in the misdemeanor case at $1,000 secured, so that is $3,500 total. If you deposit that money with the court, you will be released under the supervision of pretrial services so that you can alcohol test for us in the felony case. I did order alcohol testing in that case if you post a bond and are released. You have written release conditions in both cases that include no contact with any alleged victim. In the felony case, they do allege there was a collision. They allege that you hurt someone, but they did not give any detail on it, and they did not book you for that. The court found probable cause for endangerment in your case based on generalized endangerment caused by a person with an extreme blood alcohol. Yours was alleged at a minimum of 0.17 on a freeway. That endangers a lot of people in the community. But as to any specific person you are alleged to have hurt, they did not provide any detail or charge you yet with having done that. But you're still not to have any contact with them. Anyone involved in a collision with you or any property you may have damaged, they are entitled to seek restitution from you if you are convicted. You may not possess or consume any alcohol, no drugs without a valid prescription. You may not leave the state without the court's permission. I did see there were indications in the file that you may have faced immigration proceedings several years ago, and that's why you weren't around for the 2022 case. I don't know your immigration status. I have not factored that into my decision at all. I'm just telling you, if you leave the state, whether on purpose or because somebody made you, there will be warrants issued for your arrest in these cases, and you could lose your bail money. Everything is on your paperwork, and did you already give it to him? Or here? Yeah, thank you. Just grab your paperwork, and you can hand the officer the headphones. That's all for today. Thank you. Okay, thank you. All right. Okay, and can the interpreter make a general call just in case? So I'll have bad luck if I don't.
¿Existe alguien más presente esta mañana que necesite los servicios de interpretación al idioma español? Si puede, por favor, levantar su mano e indicarlo.
Okay. We see no hands. All right. Thank you so much. Have a great day and a good weekend.
Likewise, Your Honor. Have a wonderful day, you and your staff.
Thank you. All right. Mr. Lopez, Robert Lopez. All right. So thank you for letting me know on these. I'm gonna. We've got a victim filing a statement on number 18. So I may go in a little bit out of order. I'm going to move him down and wait for the victim to come in. Okay. Thanks. And I'll move it down, Katrina, and then just let me know when you've attached them, when they are. Yeah. Very well. All right, after Mr. Lopez will be Mr. Nunnally. If you'll go to the chair, please. All right. Oh, so this is an attorney for the victim? Oh, okay, not the defendant attorney. Okay. Yeah. All right, do they want to appear?
I
I don't know. Okay, all right, well, we'll stop until we know. Okay, all right, sorry, sir, that had nothing to do with your case. All right, can I have your full name and date of birth?
Robert Adrian Lopez,
Which date of birth?
8/31/2000.
All right, thank you. You are here on a total of 4 things. One's a new case, one's a warrant and a pending case, and 2 are probation warrants. I'm going to start with your brand new case from yesterday. You got booked in on a new charge of theft of a means of transportation. It's a class 3 felony, and there is probable cause for it. I am appointing a lawyer for you in this case. You're going to end up with the same lawyer in all of your cases.
Okay.
So, I'll give you your court dates in a second, because I'll try to tell you which ones are together and which ones aren't. Now, in your pending case, you have not been sentenced. It's open and pending. You've been charged with dangerous and narcotic drug possession. Those are class 4 felonies. Also, drug paraphernalia possession, a class 6 felony. In this case, the warrant went out for your arrest after you failed to appear at a status conference on April 3rd. And you already have a lawyer in that case. Like I said, you're going to end up with the same lawyer for everything. Now, I think it was the same date and time you missed in the probation cases. Yeah, so the April 3rd date that you missed was a status conference in your pending case, and it was non-witness violation hearings in both of your probation cases. So you caught a warrant in all 3 cases on April 3rd. All righty. So, looks like I can get you a status conference in all 4 cases because they're all going to be in front of the same judge on April 30th at 8:30 in the morning, which is this coming Thursday. It'll be a status conference in the pending cases and a non-witness violation hearing in the probation cases. Then in the both of the open cases, looks like you've not had a preliminary hearing in that pending one either. So I'm going to set a preliminary hearing for both of the open cases on Monday, May 4th at 8:30 in the morning, same court.
Okay.
Finally, in between those, on Friday, May 1st, you're going to have a bail eligibility hearing in the new case. I don't know if you know this already, but when you come in with probable cause for a new felony, while you had any pending felony case, and you do have that one, I have to hold you for a bail hearing. I cannot give you bail. You're not eligible today. But you will have a bail eligibility hearing on Friday, May 1st, 1 week from today, at 1:30 in the afternoon. On your paperwork, it says evidentiary hearing because it is one, but it's for bail. So when you're wondering, like, when was my bail hearing? It's the one called evidentiary hearing on your paperwork. All right, everything's on your paperwork. Just grab that from him. Oh, I'm sorry, I didn't tell you your conditions in the other cases. Sorry. You are held no bond in both of your probation cases as well, and you have a $5,000 secured bond in your pending case. All right, thank you. Mr. Nunnally? And then Anthony Stander, we go to the chair. Hello, sir. Can I have your full name and date of birth?
John Nunley, 3691, miss.
Okay, thank you. You're here on one new case and a probation hold.
Yes.
In your new case, you were booked in for aggravated DUI alleged 2 different ways, both as a third or subsequent DUI in the same 7-year period and as while your license is suspended. So both of those are class 4 felonies. Also, unlawful flight from a law enforcement vehicle, that's a class 5 felony. Reckless driving, a class 2 misdemeanor. Hold on, there is probable cause for all of those. They also booked you for dangerous drug possession, but they messed up because they accuse you of having cocaine. Cocaine is a narcotic drug, so they picked the wrong statute. So for purposes of this hearing only, I don't find probable cause on the dangerous drug allegation because that's not the kind of drug they're accusing you of having. Okay. It does not mean it's dismissed. I'm just ignoring it for purposes of release conditions. Yes, what was your question?
Okay, so for the DUI, so that's, so.
All right, I'm just trying to tell you why you're here. Are you trying to tell me things about what happened?
No, I'm just
Okay.
I'm pretty much, you know,
I'm trying to tell you why you're here.
Oh, okay.
Okay, so unless you have questions about the charges I just read, what I said, then I'm going to keep going.
Oh,
sorry. All right, so that's what you're accused of.
Yes, ma'am.
That's what I did find probable cause for, everything except the dangerous drugs, because they don't accuse you of having dangerous drugs. They accuse you of having a narcotic drug. So it's a mistake that the police made on the booking for the drug only. So talk to your lawyer about how that works. There is probable cause on everything else, on both of the ag DUIs, the unlawful flight, and the reckless driving. They
don't got me for, that's what I don't understand. How you gonna catch me as a DUI and, like, you know, they took a blood test, but.
It's called impaired to the slightest degree. I think it's patently probable cause that you were impaired to the slightest degree. So it's up to the state to decide whether they go forward now or they wait for the blood results, what they're going to do with you. I find that there is
ample probable cause that you are impaired to the slightest degree. Don't need a blood test for that. So you can talk to your lawyer about that. There's 100% probable cause. Probable cause is very low standard, sir.
Yeah, they
very
said-
low, and they have
said
met
your
it.
pupils, they said your pupils
Yeah.
dilated.
Mr.
because we don't-
Nunley,
Yeah.
not super impressed with your criminal history
I know.
and what you're alleged to have done, that you're arguing with
Oh,
me
I'm
about
sorry.
this
No, I'm sorry.
and
man.
trying to claim
No,
that
I'm-
you,
I'm sorry.
honestly, sir, you have the right to remain silent in a criminal case. You also have the right to contest this case and say,
Yes, sir.
I was not impaired. They also say they field tested that cocaine.
Mhm.
They field tested the cocaine. So there is probable cause that you also had the coke on you. They just didn't book you properly for it. And you're on felony probation for aggravated DUI, and it's not even your first one. And there's hard probable cause that you fled from police. So, Mr. Nunley, nitpicking about that, you can do that with your lawyer. You're legally entitled to. But
Yes,
this
ma'am.
is probable cause all day long
Yes, ma'am.
for DUI, and it
I'm
ain't
sorry.
your first rodeo.
I know.
So please
just-
talk to your lawyer about defending your case. You're absolutely entitled to defend your case. Probable cause is an extremely low standard. It is not beyond a reasonable doubt. It's not even preponderance of the evidence. So I'm just unhappy, Mr. Nunley, because even this conversation with you strongly suggests you're dangerous to the community because you do not take seriously what is happening today. You do not take seriously
Miss
your
Lady.
probation.
Just got
So-
I do, Miss Lady.
The state recommended a $50,000 bond for you because what you are accused of doing makes other people dead with great frequency. This kind of repetitive behavior, fleeing at high speeds. I believe they accuse you of turning off your lights. I think that was you. Hold on a second. High rate of speed. Yep. So, the court is extremely concerned that you will never stop doing this until you kill yourself or other people.
No, that's not
And
the
that is
case.
a community safety issue. So you can talk to your lawyer
That's
about
not the
that.
case, Miss Lady.
Okay, well, and sir, normally it's your honor. I am
sorry.
a Superior
I'm
Court
sorry about
judicial
that,
officer.
Miss
So,
Honor.
in any event,
I've been out for a whole year.
I know, and so, Mr.
And I haven't
Nunley,
caught
I'm
no other
holding you no
charges.
bond in your probation case. There's a very high probability you will be revoked to prison. And under that circumstances, you don't get bail at all in your probation case. So you can talk to your lawyer about that.
That means I'm going back to prison?
The court finds there's a high probability in your probation case, they will revoke you for this. That you don't get to, have another try. That if you're found to have done this new case, you get revoked to prison in your probation case. You're also facing 10-year presumptive in the new case. The new case, if you go to trial and lose, because you have 3 priors, 2 of which are aggravated DUI and can be alleged against you forever. You are in category 3, which is the highest sentencing category.
So my kids won't see me
For
until
the
they
rest of
turn
your
like
life.
15, 16?
Mr. Nunley, talk to your lawyer about that. Right now, you're here on very serious criminal charges.
Yes, ma'am.
So, you're not granted bond in your probation case today because there is a high probability you'll be revoked to prison. In the new case, your bond is $15,000. That's the one where the state recommended 50. If you post it, you go to ankle monitoring, and you categorically do not drive. I put it 2 places. 2 places in your paperwork. It's a crime every time you get behind the wheel of the car. No weapons, no drugs, no alcohol. Everything you need to know is on your paperwork. You can talk to your lawyer next
No, I'm
week.
ready.
Everything's there,
I'm ready.
including your court date.
There's nothing I can do about it.
Did you say it's not that big a deal?
No, I said there's nothing I can do about it because,
Well, you need to talk to your lawyer.
I know I messed up, I fucked up and watched my language and stuff like that. I was just scared. Everybody have their mistakes.
Yeah,
but
please
it's
talk to your lawyer,
DUI-wise,
Mr. Nunley.
It's DUI-wise, there wasn't no alcohol in my system. That's why I did the blood.
All right.
So when
Talk
that
to your
comes
lawyer.
back,
The
I
unlawful
hope that-
flight is still good,
Yeah,
100%
I know
unlawful
running
flight.
from the police is not right.
Go talk to your lawyer,
Yeah.
all right? You're facing some serious time on this.
I know,
Mr.
I
Sanders,
got out of prison doing 2 months.
I'm aware.
Yeah, and they got trying to send you back to a high 3 or with no DUI.
The attorney for the victim would like to make a statement because.
Okay. Oh, okay. Yeah, they can, sure, of course. Yeah, yeah. If they come into the room, they can do it.
I can just come on.
Okay, yeah, that's no problem. All right. I know he's very put upon by the legal system. Can we get him out of here?
Yeah.
Thanks. All right, Mr. Sander,
Yes.
can I have your full name and date of birth, please?
Anthony Sander, 8276.
All right, thank you. You are here on a grand jury warrant. You got booked in on charges of dangerous drug possession by transportation or sale of dangerous drugs, class 2 felonies. Sorry, one class 2 felony. So dangerous drugs for sale, narcotic drugs, simple possession as a class 4 felony. The alleged offense date for both of those is July 5th of 2024. Looks like you were indicted by the grand jury a couple of months ago. All righty. I am appointing a lawyer for you in this case. Your arraignment hearing on this indictment will be May 1st at 8:30 in the morning in the downtown Superior Court. Your bond as set by the grand jury judge is $10,000 secured. That is affirmed. If you post it, comply with all of your written release conditions. Do not miss your court dates. Everything's going to be right there if you take that with you. Thank you. All right, Mr. Lopez, Marco Lopez, and then Elijah Taylor. Will you go to the chair? Good morning, sir. Can I have your full name and your date of birth, please?
Marcos Alejandro Lopez Jr., 01-17-97.
All right, thank you. You're here on a new case. You're arrested for dangerous drug possession, class 4 felony, domestic violence assault, and domestic violence disorderly conduct. Both of those are class 1 misdemeanors. There is probable cause for them, and I am appointing a lawyer to represent you. Your next court date is a status conference, April 30th at 8:30 in the morning in the downtown Superior Court with a preliminary hearing May 4th at 8:30 in the same court. The court is extremely concerned about victim safety in your case. So bond is set in the amount of $5,000. It is secured, and you go on an ankle monitor if you post bond. Absolutely no contact with her. You may not respond to contact from her. That is not a legal defense.
Yes, ma'am.
No weapons, no drugs, no alcohol. It is a crime to violate these orders. It can be a felony if you do it in a way that is harassment. That can be one text. If a court finds probable cause for harassment, it's felony harassment, and you'll get held without bond on a new felony charge.
Okay.
Absolutely no contact with her. You may not have contact with the complainant, who apparently is your site manager.
Wait, what?
Your site manager,
What was
who reported the threat.
Sorry.
If that means you can't work, then you can't work. The court is very concerned that you're going to kill one or both of them, even though this was a misdemeanor.
Sorry.
And the victim, the evidence that you brutally beat this victim, but not in a way that yet is arising to the level of a felony, is strong, very strong. So the court believes there's good reason to believe you are in fact violent, good reason to believe that you threatened to kill your significant other, and you communicated the threat to a third party, which red flag-wise statistically greatly increases the risk that you will hurt or kill her eventually.
Oh, man.
And so don't give anybody any reason to think that. So comply with your release conditions. You're on an ankle monitor to ensure that you cannot live where she lives. You can do a civil standby to collect belongings, and then you have to find another place to stay.
Okay.
You step to your left, you get copies of your paperwork. Thank you.
Take
Mr. Taylor? And then Cole Spencer, will you go to the chair? Hello, sir. Can I have your full name and date of birth?
Elijah Taylor, 12/28/99.
Thank you. You're here on four things, sorry. One is a new misdemeanor. One is a misdemeanor warrant out of a different city. Two are probation holds in both of your felony probation cases. In the new case, you were arrested for interfering with judicial proceedings by disobeying an order of protection. It is a class 1 misdemeanor. There is probable cause for it, and I am appointing a lawyer for you. Your court date for this new case will be an arraignment hearing April 28th at 9 in the morning in the Peoria City Court, and the address is on your paperwork. In the Tolleson City Court, a warrant was issued for your arrest. It's a failure to comply in a drug paraphernalia misdemeanor case. The warrant was issued March 18th of 2026. Your arraignment hearing in the Tolleson City Court will be Monday, May 4th, 8:30 in the morning. That address is on your paperwork. The probation department has filed a term 1 hold against you, which is commission of a new crime, which violates your probation. So there will be a petition to revoke your probation filed based on the interfering with judicial proceedings arrest, the new arrest. You're on probation for 1 Class 3 and 1 Class 4 felony. I'm appointing a lawyer for you in both of your probation cases. Your court date in probation court is April 30th, which is this Thursday at 8:30 in the morning in the downtown probation court. It's a revocation, arraignment, and possible disposition hearing. For the reasons detailed in the court's written order, the court is extremely concerned that you are a specific risk to the alleged victim in the order of protection case, and that it has been very, very clear to you that you are not to have contact with her by order of the Phoenix Municipal Court, and that your probation officer has repeatedly talked to you about it and was well aware that you were violating that, and apparently attempted to get your deferred jail term, that further deferral, to get it stopped. The message didn't make it to the judge in time. So the court believes you were extremely deliberately violating that order, that you are an active and ongoing risk to her. So your bond is set in each of your probation cases at $2,500 secured. That's $5,000 total. In the interfering with judicial proceedings case itself, your bond is $1,000 secured, and in the Tolleson City Court case, your bond is $50 secured to make you eligible for credit. So that is $6,050 total if you bond out. Comply with every one of your release conditions, categorically and absolutely no contact with Brooklyn Stockton. You may not respond to any contact from her. It is not a legal defense.
Can I ask you a question?
Sure. Remember your Fifth Amendment right.
Okay, so I heard everything you said and all that. What if she chooses to get that restraining order?
She can choose whatever she wants. You can't ask her to. You can't tell her to. You can't ask her if she did. How you would find out, I don't know, and I don't care. Because, Mr. Taylor, you also washed out of DV classes. So the odds of you committing witness tampering are off the chart, based on what was alleged from yesterday, that Mr. Taylor categorically zero contact with her. It is a very simple proposition. No contact with her. If you find out in a verifiable way that the order of protection went away, then you still need a court order in all 4 of these cases. No, 3 of them. I didn't do it in the Tolleson one. You need a court order. The court order is now there. It is a felony to violate that in any way that is harassment, which can be 1 text. It is at a minimum a misdemeanor to contact her at all in violation of these criminal court orders. You've got an order of protection. Now you've got 3 criminal court orders. You need an order in every single case.
How do I go about getting...
I do not give legal advice. I can't.
Okay.
You have a lawyer in every case.
Thank you.
Don't contact her. You can step to your left. Mr. Spencer, Cole, oh, wait, this is the one? Sorry. No, it's Mr. Spencer, we have a victim's attorney coming to speak in your and the co-defendant's case. So go ahead and have a seat.
On yours, but he's not on mine.
Oh, wait. Okay, yeah. Hold on. Just stay where you are. Let's see if we can get him in.
Can you add him?
Yeah.
He's not showing up on mine.
Let me see. I want to make sure this is working. Okay, hold on 1 second, counsel. We just realized, okay, sorry, we're messing with the... All right, okay. Okay, 1 second. All right, can you hear me, counsel? Counsel, can you hear me? You got to unmute if you can. Still can't hear you.
He's not even showing up on mine.
Well, I think we're having a bit of connection
I'm
issues.
gonna close it and have him on my phone.
Okay, can you give it about what, 1 minute, 2 minutes?
Yeah, just a minute.
Give it like, we're gonna close and restart the app, counsel, so will you log out? Or, well, we're gonna dump you. Can you hear me? Can't tell if you can hear me. And then log back in 1 minute. Go ahead and sit, sir. I'm gonna call a different case while we try to get this, well, no, are we gonna be off the record?
No.
Okay. Okay. All right, let's go ahead to Teresita Olvera, if you come to the podium. Tell me when you're ready. Hi, ma'am. Can I have your full name and your date of birth?
Teresita Olvera, 52288.
All right, thanks. You're hearing a new case. You got arrested for dangerous and narcotic drug possession. Those are class 4 felonies. Also, drug paraphernalia possession, class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. Your status conference will be April 30th at 8:30 in the morning. That's a Thursday in the downtown Superior Court. Your preliminary hearing will be May 4th at 8:30 in the morning. Same court, downtown. The address is on your paperwork.
Thank you.
And it looks like you have a DOC hold that's been placed on you here at the jail, so just warning you. You do have a $1,000 secured appearance bond in this case. Just know that if you post that, DOC is going to get a call, and they'll have 24 hours to come and pick you up. And if you end up in DOC custody when your court dates roll around, you'll catch a warrant, and you'll end up popcorning back and forth between the systems. So you may want to consult with your lawyer before you post that bond, but you are allowed to if you want. He's kept you. Okay. So, counsel, I don't know if you can hear me, but we have to restart our whole system. My staff is having trouble with the management system, so we have to go off the record while we do it, right? Okay, it's going to be a couple minutes while we try to restart the audio visual. All right. Running? Okay.
There's another number in there that.
Okay, right, and so we have, all right, so, let me turn the camera on. Right, and so, counsel, can you hear me now?
One moment. I'm trying to turn on live captions. Hold on a second.
Okay.
I can read them.
Okay, I'll say some words to see if it's testing.
Yes, Judge.
Okay, are you good to go? Okay, thank you.
It's helping that I can read it.
Okay, and do me a favor, can you mute on your end when you're not talking? Because we're getting a smidge of feedback. It sounds like birds chirping. So maybe just when you're not talking, mute.
I'm reading.
Not sure how.
Saying, Your Honor. Is that good? Did that work?
Yeah,
I turn my phone down.
I think that helped a lot. Are you able to mute your phone, or do you need the phone to make sound so that your system works?
No, I need the phone. It Bluetooths to my hearing aids.
Okay, do this. Try to keep the phone, like arm's length from the computer or your hearing aids, and maybe that'll help with the feedback. Like leave it on, but move it away.
Does that help if I turn it down more?
Let's see. I'm going to say some more words. That helped a lot. It's very faint now. I think that's much better. Thank you. Okay. All right. Let's go ahead with Mr. Spencer's case, and then we're going to do Alex Leeper right after that. All right. All right, sir. Let's start with your full name and date of birth, please.
Cole Joseph Spencer, 10/23/85.
All right, thank you. And then the appearance of counsel, please.
Me or the state? Okay.
You. No, right. No, she's not here.
Michael Urbano on behalf of victim Zagana Little Wing Urbano.
All right, thank you. Mr. Spencer, you have been arrested on new charges, and there is a term 1 hold in your probation case, which I'll explain in a moment. You've been accused of 3 counts of burglary in the 3rd degree, all class 4 felonies, 1 count of attempted burglary in the 3rd degree, that's a class 5 felony, 1 count of theft by control of a stolen credit card as a class 5 felony, and 1 count of fraudulent use of a credit card as a class 1 misdemeanor. Based on what the police presented, there is probable cause for all of those allegations, and I am appointing a lawyer for you in this case. I'm also appointing a lawyer in your probation case. You are on probation for burglary in the 3rd degree, a class 4 felony. The probation department will be filing a petition to revoke your probation based on this new arrest. So you will also have a lawyer appointed in that case. Your next court date will be the same for both cases. It is Thursday, April 30th at 8:30 in the morning in the downtown Superior Court. That will be a status conference in the new case and a revocation arraignment hearing in the probation case. Then we are also scheduling a preliminary hearing for May 4th at 8:30 in the morning in the new case only. Before I set conditions of bail or release, I'm going to hear from the victim's attorney. Please go ahead, sir.
Thank you, Your Honor. And I'm sorry, the screen shows Katrina Manders. I'm sorry, which defendant is this?
So this is Mr. Cole Spencer. I'm Commissioner McLaughlin, and Alex Leeper is next.
And this is Mr. Spencer, Your Honor? Is that right?
Yes, Mr. Cole Spencer.
Okay. Your Honor, and I thank you for the court's time and just wanted the court to know on behalf, the victim is my daughter. She is really freaked out about this, and I just heard about it in the middle of, last night and more this morning, and she's, did the court get my notice of appearance and victim impact statement? I was really rushed to get those out this morning.
It did come through, thank you. Wait, let's see. This is the NOA, hold on. There it is, okay, sorry. It did come through, thank you. Can you give me 1 minute to read it?
Yes, please.
Okay, thank you. 1 second, Mr. Spencer, I am obligated to read this. Okay, thank you. Go ahead, counsel.
Thank you, Your Honor. My daughter Ziggy, she's just a wonderful, wonderful child and young adult, and she works really, really hard. She barely makes it, and she's working as a manager in a grocery store right now until she moves up to Washington this summer in September for graduate school. She's barely making it, and now her car, she's lost her sense of security, and I'm hopeful that this won't affect her too long in a negative way. Is that she's just been the way to describe her, I guess, she's always been she's very anti-military. She's not like me at all. I was in the military and all that, and a pilot in the military. She believes that, everyone is wonderful and good, and I just hope this doesn't sour her. And I understand and appreciate that, all defendants are presumed innocent until proven guilty, and she appreciates that too. She's gone to court with me many, many times as a defense attorney, and I'm hopeful that both these defendants will appreciate and learn from this and know that, things like this do personally affect people. It can harm them for the rest of their lives, and I hope they can learn from it.
All right, thank you very much, counsel.
Thank you, Judge.
Mr. Spencer.
Your Honor, may I speak?
You can, but Mr. Spencer, I do really want to caution you about your right to remain silent. It's very hard for defendants to listen to other people talking about what they're accused of doing without wanting to respond. It's natural. But the things you're saying are being audio and video recorded, and they could be used against you either now or at any later hearing in what, because of your criminal history, could be a prison mandatory case. So I did give you a lawyer, but your lawyer is not standing here to speak for you. Your lawyer can tell your side of the story and not have it potentially get used against you. You risk that happening.
Fully aware.
All right. So as far as release conditions go, I certainly encourage you to talk about that. If you choose to talk about what you've been accused of, I will listen, but I would certainly urge you to remember your right to remain silent. Do you understand the warning I just gave you?
Yes,
okay.
I understand.
Then what did you want to say?
I want to make it clear to the court that myself, and especially Miss, I don't know her last name. What's her last name? Lieber?
Lieber.
We were unaware of, well, I was unaware. She didn't know what I was doing. She's being charged for these crimes. I asked her to give me a ride. She was literally crying. in the car. Hey, what are you doing? Asking me what I'm doing. I made a poor decision. I understand that this is incriminating to myself. She didn't do anything. All right?
I understand.
Furthermore, I was unaware of this person, the age or, you know, how old she was or what her job was, and I apologize. You know, if it's caused her any grief or it's taken any sense of security out of her life, it's pretty much all I got, Your Honor.
All right, thank you. I've considered what's been alleged against you. I've considered your criminal history, which is very extensive. And as I note in my written order, you have approximately 12 prior convictions. Most of them are for burglary. You just did 9 years for burglary, and there are multiple victims and multiple crimes alleged in this case with what appears to be a very strong weight of evidence. So in your probation case, the court finds that you will, in all reasonable probabilities, be revoked to prison. And in your new case, so you don't have bail at all in your probation case, not today. You are held without bond pursuant to Rule 7.2C. Now, in the new case, the court believes that your risk of non-appearance, new criminal activity, and non-compliance with the release conditions just couldn't be higher. So even though you may feel remorse, and I understand that, and I don't think your remorse is insincere, I'm just saying the court believes there's a very high probability that you're not going to show up for court hearings because you know what you're facing, and that you're likely, as likely as I've ever seen anybody, to commit burglaries to support yourself while you're out of custody. So I'm setting bail in your new case at $25,000, and it's cash only with written release conditions. That does not change the no bond holding in the probation case. So you shouldn't try to post bond in the new case until you know whether you can get any bond in your probation case.
Will I be able to get a bond in my probation case?
You have to talk to your lawyer. You're entitled to file a motion to modify. The state will respond, and the probation court or whoever the case is ultimately assigned to, they will make a decision. I believe that the legal standard is very amply met in your probation case, which is that there is a very high probability on these facts, if the state has the evidence that they say they have in the new case, that the probation violations are too many, too great, and they are directly the thing that you are on probation for, with so very many priors for it. So talk to your lawyer about that. In the meantime, of course, absolutely no contact with any of the alleged victims. If you're out of custody at any point, don't go to any of the scenes of the crimes. Don't have any contact with your co-defendant. She will be ordered not to have contact with you. And that's from this moment forward. I mean, so we'll just have you go sit in the back row. And you'll talk to your lawyer next week. You'll be back in court on Thursday. And you can talk to your lawyer about your total situation. I heard you say it. Yes, thank you. All right. Okay, then let's get Ms. Leeper up here. All right, right here at the podium, please, ma'am. All right, ma'am, may I have your full name and your date of birth, please?
Alex Marie Leeper, 9/22/87.
All right, and then, Mr. Urbano, if you go ahead and appear again in this case.
I'm sorry, which defendant is this, Judge?
This is Alex Leeper. Do you need me to spell it?
Okay, I was expecting a male. I'm sorry. Good morning, Your Honor. Again, Attorney Michael Urbano on behalf of victim Zagana Littling Urbano.
All right, thank you. All right, ma'am, you are before the court today on 2 allegations of, sorry, one of them they just listed it as the wrong class of felony. It is a total of 3 allegations of burglary in the 3rd degree. Each of those is a class 4 felony. Also, 1 allegation of attempted burglary in the 3rd degree, and that is a class 5 felony. Based on what the police presented and understanding that your co-defendant is saying you did not know and you weren't participating, the court does not find that credible in light of what the police are accusing you of. And so I do find there is at least probable cause for these crimes. As your lawyer will explain to you, probable cause is a fairly low standard compared to beyond a reasonable doubt. So talk to your lawyer. The county attorney will decide what, if anything, you might be charged with in this case. These are your booking charges, and there is probable cause for them. So I'm giving you 2 court dates, and that is going to be a status conference, April 30th at 8:30 in the morning. That's this Thursday. This Thursday, 8:30 in the morning in the downtown Superior Court. Oh, and officer, I need to reprint this because I need to give her the legal defender.
Yep.
Nobody's coming through as co-defendants anymore, so we have to do it manually. Okay.
Name for 002?
Yeah, oh, yeah, will you do that? Thank you. And then I'm going to fix the class of felony on that other one while we're at it. Okay. Yeah, okay. All right, sorry. We're just sorting out some system things. Sorry, so your status conference will be this Thursday, April 30th, 8:30 in the morning, with a preliminary hearing Monday, May 4th at 8:30. Those will be in the downtown Superior Court, address on your paperwork. Before I set conditions of bail or release, counsel, what did you want to say? And I do remember, and I'm also considering everything you said for the previous defendant, but please go ahead.
I'm sorry, you're talking to me, Judge?
Yes.
Yeah. Again, thank you, Your Honor, for allowing me to appear this morning on behalf of my daughter. Again, I mean, Ziggy is just such an old soul, very kind, very trusting, and very, I mean, she's an animal rights activist. She's, you know, very active with the Native community. And, you know, she's a vegan, and just, I don't want her to lose her sense of security on this, and it's kind of affected her. She's seen me in court many, many times, but this is the first time that she's ever been a victim of a crime. And I'm just hopeful that this young woman will learn from this experience, whatever happens, you know, if indeed she has nothing to do with it, you know, choose better company. So.
All right. Thank you very much. All right. And ma'am, I've just, yeah, no, I'm reprinting on this, okay? All right. I just reread carefully the probable cause statement in your case, ma'am. And I believe I had misunderstood when I read before. I thought it was alleged that they had evidence you had used one of the credit cards. They don't. That they allege Mr. Spencer used one of the credit cards. So on these facts, I do still find probable cause. But I believe that given the weight of evidence against you is much less than it is against your co-defendant, and you don't remotely have his criminal history. I believe you have no prior felony convictions. You have none. So, counsel, let me go back to you if you wanted to be heard on this. Her pretrial risk assessment suggests, although I am concerned about her potential ties to the community, not having a regular place to stay, et cetera. So it suggests that she doesn't need supervision in the community while the case is pending. I would be inclined to perhaps release you to pretrial services supervision to make her check in, to help us keep track of her and her keep track of her court date. But I'd like to know if you wanted to be heard on that, counsel.
Your Honor, I think that's very appropriate.
Okay. All right. So, Ms. Leeper, in light of the fact that you don't have nearly as much evidence alleged against you, the fact that you don't have that criminal history, I am also considering the co-defendant said things that tended to exculpate you here in court. People can have motives to do that, that don't involve the truth. So I take it with a grain of salt. The man has 12 prior felony convictions, but I did hear it. So I'm going to release you to pretrial services, okay? So it's going to move your court dates out. So your status conference will be May 8th at 8:30 in the morning. Preliminary hearing, May 12th at 8:30. The address will be on your paperwork. I did give you a lawyer, and I also put a phone number on your paperwork for criminal court administration. I recommend you call a few days before your hearing on May 8th and ask if your status conference is still happening, because it's up to the county attorney now has more time to decide whether to charge you or not. And if they decide not to charge you right now, these court dates and orders could go away. So calling early is just a way not to waste a trip downtown. But if the charges do get filed and you're not there, there will be a warrant issued for your arrest on May 8th. You're going to get an envelope that tells you how to call pretrial services after you are released. Don't lose the envelope, don't lose your paperwork, so you know what to do when you get out. Okay. If you miss a court date, it's very likely you'll end up with a bond once you're seen on the warrant, okay? Absolutely no contact with any alleged victims. Do not go to the scenes of any alleged crimes. Absolutely no contact with Mr. Spencer. Okay, anything else from counsel?
Yes, Your Honor. I would also like to suggest with pretrial services, and of course it's up to the court's discretion, but suggest random drug screening and a curfew, so this young woman appreciates and takes this court process seriously and hopefully remains out of trouble. And you know, again, if she had absolutely nothing to, if she was just around the other defendant when this occurred, I can certainly understand that and appreciate that. But I would like and hope that this, she takes this very seriously, and I think with a random drug screening and a curfew with a pretrial services would help facilitate that, and hopefully she'll never see this courtroom, the inside of a courtroom again.
All right, so thank you, counsel. And ma'am, I am going to allow pretrial services to set a curfew for you. I'm not going to order drug testing because right now the police haven't alleged anything against either of you in connection with drugs. I think the victim's attorney and the court weren't born yesterday and aren't under any illusions about the substantial probability that one or both of you may be engaging in illegal drug use and he may be funding it through burglaries. But that isn't alleged against you. You don't face a drug charge right now. And so right now, let me look at your criminal history before I make a final decision on that.
And Your Honor, if I may, I didn't mean to insinuate any kind of a nexus or a connection. I've just, as a defense attorney for 20 years, I've seen that happen a lot. That was, you know,
Sure.
theft related to
burglary. Agreed.
I'm sorry, burglary related to drug crime. So I would leave that.
And I see your drug paraphernalia arrest, ma'am. I don't see a resolution of it, and it's one of those where certainly if I was a betting person, I would bet that you are. That being said, I'm not going to do it today again for the reason that I said, but also because it looks like you don't have a reasonable place to stay. It can be difficult and expensive to get to drug testing, and especially if you're not getting any treatment. In any event, what we have found, counsel, is that it can cause people to FTA because they think they're going to get remanded for failing to test, or they're afraid that they did just go test dirty, and it will actually sort of have an unintended result, at least in the early stages. So, of course, if I was a betting person, I would bet Ms. Leeper could use some drug treatment. But right now, she's here on the burglary. So not today. I don't think it's unreasonable, counsel. I also would make the same bet, but I think at this point, I'm not going to order that, Ms. Leeper. There are resources available to defendants if you end up on probation. There's not really anything available to help people pre-trial. And, you know, you have yet to be formally charged in the case. So what you need to do is keep your nose clean. Don't miss any court dates. You're literally the opposite end of the spectrum from your co-defendant. He has the record of all records for this and is staring down the barrel of a lengthy prison term for it. You're not. Even if you went to trial and lost on these charges, they're probably all probation eligible, although it's multiple crimes victims. But there's a reasonable likelihood of a probation outcome. A lot of that depends on how you do between now and any trial. And so even if you do get charged, you have a lawyer to help defend you. You must show up for that to happen. If you come in on a new felony, you're going to get held no bond, at least in the beginning, like you saw happen. So, do you understand all that, ma'am?
Yes,
And will you come to court and comply?
Yes, ma'am.
All right. Then you are released. And counsel, thank you very much for your time.
Thank you.
Thank you, Judge.
You're welcome. You're welcome to disconnect.
Thank you.
All right. Thank you, ma'am. Okay. And let's keep going with Ms. Olvera. Terry Olvera. All right, where's Miss Olvera? Tennessee. Oh, I think I already saw her. I think I saw her. Sorry. I got all of her. Tiffany Hubbard. Hubbard. And then Vernon Ford. Hi, ma'am. Can I have your full name and your date of birth?
Tiffany Hubbard, 11/9/79.
All right, thank you. Whoops, got off the wrong page. Okay, ma'am, you are here on two things today. It looks like they are both probation violation warrants. You are on probation in two felony cases, and there were petitions to revoke your probation filed last August 13th. The petitions allege that you violated terms 3 and 5. You will get copies of those from your lawyer, and I am appointing a lawyer to represent you. Your next court date in probation court will be April 30th, 8:30 in the morning in the downtown probation court. The address is on your paperwork. I'm just going to affirm the bond set by your probation judge, $500 per case for $1,000 total. If you bond out, comply with all of your conditions and call your PO within 72 hours. He's got that for you. Thank you. All right, where's Mr. Ford? And then Julio Amara, will you go to the chair? Hello, sir. Can I have your full name and date of birth?
Vernon Glenn Ford, 42677.
Okay, thank you. You're here on two probation violation warrants. Also, there was a new misdemeanor booking, but I'm going to start with the probation warrants, okay? You're on probation in two felony cases. There were petitions to revoke your probation filed in both cases about a month ago. They allege that you violated terms 3 and 5. You'll get copies of those petitions from your lawyer, and I am appointing a lawyer to represent you in probation court. Your court date there is Thursday, April 30th at 8:30 in the morning. The address in downtown Phoenix is on your paperwork, and your bond in each of the two cases is $250 secured for $500 total. If you bond out, you got to comply with your release conditions and call your PO within 72 hours. Now, you're also booked into Peoria City Court for a drug paraphernalia misdemeanor. I'm going to give you a court date there, which is May 12th at 9 in the morning. It's so far out because I didn't find probable cause in your case. They didn't meet the legal standard. I don't personally doubt what it was, but there's a legal standard that the police have to meet in their booking paperwork. They didn't. So for today's purposes only, I'm not finding probable cause. But it's not dismissed. So you still have to go to the Peoria City Court May 12th at 9 in the morning. You're just entitled to be released on that misdemeanor. You still have a probation problem. So I'm just not adding any bond for the Peoria case. But keep track of that paperwork so that when you're out of custody, you can call that court and find out what happened, okay?
Okay.
All right, good luck, sir. Mr. Amara, Julio Amara, and then Peter Garcia, will you go to the chair? Hello, sir, can I have your full name and your date of birth?
My name is Julio Cesar Amara. My date of birth is December 7th, 1981.
Okay, thanks. You're here on a probation warrant that issued in your felony probation case on December 3rd of last year. The petition to revoke alleges that you violated terms 6 and 7. You'll get a copy of it from your lawyer, and I am appointing a lawyer to represent you. Your court date in the probation court downtown is April 30th at 8:30 in the morning. It's a revocation, arraignment, and possible disposition hearing. The address will be on your paperwork, and I'm just going to affirm the bond set by the probation judge, which is $250 secured. If you post it, comply with all of your conditions, call your PO within 72 hours of release.
All right.
Good luck, sir.
Thank you.
Mr. Garcia, Peter Garcia. And then Keenan Johnson, if you go to the chair.
Hello, Your Honor.
Hello, sir. Can I have your full name and your date of birth?
My full name is Peter Joshua Garcia. Date of birth is December 21st, 1997.
Okay, thanks. You're here on a new case. You got arrested for drug paraphernalia, possession of Class 6 felony, and dangerous drug possession of Class 4 felony. There is probable cause for those, and I am appointing a lawyer for you. Your court dates are in 2 weeks. The first one is a status conference, May 8th at 8:30 in the morning, with a preliminary hearing May 12th at 8:30. The court address will be on your paperwork, and you qualify for release on your own recognizance in this case. I show you have a City of Phoenix warrant. Did you see a City of Phoenix judge at 10?
Yes.
Great. Did they release you?
Yes.
Then you, provided you don't have anything else, then you will be released, because I just released you in this case also. Comply with your conditions. No weapons, no drugs without a valid prescription. Come to court, or there will be a warrant issued for your arrest, okay? All right, good luck, sir.
Thank you, ma'am.
Sure.
Thank you.
All right. Mr. Johnson? Any Keenan Johnson? Yeah, okay. And John Mahaney, if you're ready, you can come in and we'll get Mr. Johnson teed up. Give him a chance to wake up. Hi, sir. Can I have your full name and date of birth?
John Mahaney, December 1st, 1980.
Okay, thanks. You're here on a warrant from the Santan Justice Court. It is an initial arrest warrant, which means they tried to send a constable to find you with a summons and couldn't, or maybe they tried to mail it to you, but it's an initial arrest warrant, which means you have not missed any court dates that you knew about. So, you've been charged in that court, Santan Justice Court, with 3 counts of DUI. So that's impaired to the slightest degree by drugs. Oh, I apologize. 2 counts of DUI. The third one is misdemeanor drug paraphernalia possession. And all 3 of those are alleged to have occurred May 1st of 2025. It looks like this came out of the Mesa PD, so somewhere in Mesa. But you'll get a copy of the police reports and the charges from your lawyer. I am appointing a lawyer for you. Your next court date is going to be an arraignment hearing May 12th at 9 in the morning. That's about 3 weeks from now. Address is on your paperwork. It's somewhere in Chandler, I think, Santan. And you qualify for release on your own recognizance. And I forgot, I did look it up. They tried to send you a summons and the constable couldn't find you. So I don't think you're any riskier today. The pretrial services suggest, and I don't think they're wrong, that it'd be nice if I could have you supervised by them and do some drug testing, but that's not available in justice court cases. I can either give you a bond or release you. I'm going to release you because this is not a new case, and it looks like they didn't book you at this point for what you are alleged to have had yesterday. So anyway, so I'm releasing you. You better be at that court hearing, Mr. Mahaney. You've got felony priors.
Yes.
And there's going to be a bond if you miss a court hearing in this DUI case. So
Yes, Your Honor.
You got till May 12th to figure out how to get there, okay?
Yes,
You're
Your
going
Honor.
to give your paperwork. Good luck.
Thank you, Your Honor.
All right, Mr. Johnson, did we get him woken up? Okay, right here, sir. And then Angie Gammon, you'll be last. Hi, sir. Can I have your full name and date of birth?
2297.
Are you Keenan Pierre Johnson?
Yes.
Okay, thanks. You're on a new case. You got arrested for possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. You're going to have a status conference in 2 weeks, which is May 8th at 8:30 in the morning in the downtown Superior Court. Your preliminary hearing will be May 12th at 8:30 in the same court. All of this information will be on your paperwork. That's about 2 weeks from now. You qualify for release on your own recognizance. That's what I'm going to order. It looks like you don't have any felony priors, so just comply with your release conditions. Don't miss your court dates, okay? He's got that paperwork for you. All right, good luck, sir. All right, and then Ms. Gammon. Hi, ma'am. Can I have your full name and date of birth?
Angie Gammon, 51180.
All right, thank you. You're here on a city court warrant from Goodyear, and it looks like you've been charged there with theft by shoplifting alleged 2 different ways, both on January 7th of 2025. Both are Class 1 misdemeanors, and in this case, it looks like this was a first failure to appear from either a citation or a complaint, so I am going to release you. Your arraignment hearing is going to be May 13th at 1 in the afternoon in the Goodyear City Court. I'm not appointing a lawyer for you because we don't in this type of case unless the state is, well, we don't do it here if we're releasing you. The city court is unlikely to do it unless the state says they're asking for jail time, so you can deal with the city court judge. What you do have, as always, is the right to hire a lawyer at your own expense, or you can just go represent yourself. So I'm going to release you on your own recognizance, May 13th, 1 in the afternoon. Don't go to this store, wherever this was. No contact with any alleged victim, complaining witness, arresting officer, or co-defendant. Don't miss your court dates, okay? So it's all right there.
Thank you very much.
Good luck. All right, then we've got 2 house calls, Officer Logan Garrett and Nathaniel Chamness. Are they both not physically present in court because they've been isolated as potential risk of danger to themselves or others?
Yeah.
All right, I did get an affirmative answer from the sheriff's office. So I will see Mr. Garrett and Mr. Chamness in person for their initial appearances back in the cell block immediately after this recording. I advise Logan Jacob Garrett, born March 27, 2000, is hearing a warrant from the Winslow Justice Court, and it is a failure to comply post-conviction warrant in a case in which he's on misdemeanor probation up there for DUI by drugs, which is a Class 1 misdemeanor. Looks like they also have charged him with failing to comply with a court order. Doesn't seem like that's a charge, but okay. And the warrant issued April 2nd of 2026. All right, I'm going to set an arraignment hearing up there in Winslow for him Wednesday, April 29th at 8:30 in the morning, and give him a $500 secured appearance bond because the court's concerned he's not going to appear up there. That is about 20% of the bond less that the Justice Court set, but I believe it should be sufficient to get him there. And so for that reason, I did note that they should appoint a lawyer if he can't post a bail. All right, Mr. Chamness, Nathaniel Lee Chamness, born 5/30/2002, turned a bench warrant in 5 different cases. One is a pending case, I believe that's number 26 on the calendar, and the court hearing he missed on March 30th was a status conference in that case in which he's been charged with possession of dangerous drugs, a Class 4 felony, drug paraphernalia, Class 6 felony, and 3rd-degree criminal trespass, a Class 3 misdemeanor. That court hearing was also a non-witness violation hearing, a revocation arraignment hearing, and I'm wrong. Right, he also failed to appear on March 20th in the probation court for revocation arraignment hearings in all 4 of his felony probation cases, and warrants were issued. So those are also bench warrants. And so I'm going to give him the same next court date. It's April 30th, 8:30 in the morning, in the downtown probation court. And in his pending case, his bond is $2,500 secured. That's number 26 on the calendar. In his oldest probation case, in which he's on probation for 3 significant felonies, his bond is $2,500 secured, and it's my intention to set $500 secured in each of the other 3 probation cases for a total of $6,500 with written release conditions in all of the cases that do include in the new pending case. I guess it's not a victim case. Anyway, for all of them, no weapons, no drugs, not a valid prescription, no alcohol, and he has to call his PL within 72 hours of any release. All right, if anything changes after I see Mr. Chamness or Mr. Garrett to conduct these initial appearances, my final order will reflect the court's ultimate decision in the cases. I'm not going to update this recording unless I have a reason to do that. So we will stand in recess now until 2 p.m. this afternoon.